May I please, Your Lordship?
Yes.
My Lord, I have one unlisted motion, petition,
Mm.
FA2. It was submitted on 8th of this month,
Mm.
but it has not been listed till date.
Mm.
So if Your Lordship be
Why is the urgency? Why can we
Lordship,
take it up tomorrow?
Lordship is very urgent for the fact that
Mm.
the Deputy Commissioner, after having passed it,
Mm.
you know that
Mm.
sent us a letter only last night
Mm.
stating that he is going to disperse the amount
Mm.
today. That is why we have come for that, Lordship. And after passing the interim judgment order,
Mm.
we have already filed a appeal petition here.
Mm.
But unfortunately, it has not been listed. And now, if a stay is not granted today, then they will disperse the money and then
Regarding what?
it's
Disperse
a land compensation,
land compensation.
Lordship. So if it can be taken up after the course of the day.
Okay, let's see. Yes. You give the mention memo.
Yes,
Yeah, give some.
Okay then, yes.
Much.
We'll see. Yes. Mm.
A big number three. I'm a petitioner. Consensus, it's a consensus period. It's a better information taken up after 3 weeks. My lady.
Criminal petition.
Sorry, my lady.
Criminal petition.
Criminal petition 3. Criminal petition before
Yes.
petition 3.
After 3 weeks.
Up 3 weeks.
3 weeks. Okay.
Technical.
no problem.
Learned counsel for the petitioner, Mr. Fosiko Fote, submits that he has some difficulties today and accordingly prays for listing the matter after 3 weeks. So learned counsel for the informant, Mr. Such and Such is present, as well as Mr. Tipapom, learned PP for the state respondents. Yes, list up to
My lady, keep it in interim. Can you take?
the interim order passed earlier shall continue till the next date. Yes.
My please, Lordship, my Lord, I beg to mention item number 23. My Lord, I'm mentioning on behalf of Ms. Mommy. I've taken consent from the opposite party. Kindly list the matter after 2 weeks.
2 weeks.
Lord.
Learned counsel for the petitioner, Mr. Moy Jami is present. Learned government advocate, Mr. Tipapom, makes a mention on behalf of Mr. V. Zimomi, learned government advocate, appearing in the matter to list the case after 3 weeks.
2 weeks.
After 2 weeks. Stop. Prayers sent out list after 2 weeks. Mr. Joshua Sheki is present for
Respondent number 5.
respondent number 5. After 2 weeks.
Much obliged.
Yes, Your Lordship, I beg to mention item number 11. If we may be granted 3 weeks time to file an affidavit in reply.
Learned counsel for the petitioner, Miss, your name?
I'm Divina.
And such prays for 2 weeks, 2 weeks time to file a reply to the affidavit of the state respondents. So prayers sent out list after 2 weeks. Learned government advocate, Miss S. Mary is present. Yes.
Please, my ladyship, I beg to mention item number 17.
Yes.
My lady, here I have instruction to appear on behalf of respondent 1 and 2. So can you grant me 3 weeks time to obtain instruction?
Okay. Learned counsel for the petitioner, Mr. Moy Jami is present. Learned additional advocate general, Miss V. Shukri, submits that she has received instructions to appear on behalf of respondent number 1 and 2 and 3 weeks time
Yes.
to receive instructions and to file her Vaklat Nama. So prayers allowed list after 3 weeks. Yes.
Again, item number 18. I have instruction to appear on behalf of respondent number 2 and 3. So here also, my lady, may kindly grant me 3 weeks time.
Okay, same order, but petitioner's name will be different, petitioner counsel.
I have instructions to appear for respondent number 1.
Okay, and here, V. Shukre will be for 2 and 3, and Mr. N. Nangami for respondent 1. You also 3 weeks.
Yes.
Okay, respondent 1, 3 weeks then, okay.
Similar prayer in item number 19.
19
The same
for
respondent.
2 and 3.
Yes.
In 19 also, respondent 2 and 3, and then respondent 1, and same petitioner, okay? Yes.
Much.
We please, Your Lordship.
Lordship, I beg to mention hearing item 25 and 26, Lordship.
Mm.
Here for the respondent number 4.
Yes.
Lordship, may kindly list this matter after 2 weeks.
Yes.
Maybe if a date may be fixed to 2 weeks.
You give your convenient date. Mr. V. Koza, learned counsel for respondent number 4, prays that the matter may be listed when after
4th of
2
May,
weeks,
Lordship.
4th May, on what ground?
My senior
As the senior, as the
Asia.
his senior, Mr. Azo, is on medical treatment. Stop. The learned government advocate, Mr. K. Angami, is present, as well as Ms. Lucino for the
Maybe
petitioners.
interim may be extended till.
Yes, it's list on 4th May. 4th May is okay. 4th May for hearing. So the interim order passed earlier shall continue till the next day. Yes.
Much.
I'd like to mention item number 20 and 21, maybe.
Yes.
I have instructions to appear for respondent number 2 in both the cases. So if I may be granted 3 weeks time to file my power as well as my counter.
Learned counsel for the petitioner, Ms. Such present. Stop. Ms. Lucino enters appearance for respondent number 2 and prays for 2 weeks. 2 weeks time to file her affidavit in opposition. So learned PP, Mr. Tiva Pom is present. So what about you?
My lord, we are on behalf, please a moment, my lord.
No, you have to produce the CD on the next day.
Yes.
Stop. Such and such list after 2 weeks. Yes.
Your Lordship, there is an interim.
The interim order passed earlier shall continue till the next date.
Lordship,
Hmm.
Lordship, I beg to mention item number 13.
13.
Lordship, 13.
Hmm.
Lordship, I have sent for waiting, so if 2 weeks time, you can recommend to me to file my affidavit.
Not
Learned counsel for the petitioner, Mr. Such and such present. Ms. Pichano Kitan, learned government advocate, prays for 2 weeks.
Lordship.
2 weeks time to receive instructions and to file the
I have
affidavit.
sent for waiting, Lordship.
For vetting.
Lordship.
Okay. We'll just say to file the affidavit
Yes.
on behalf of the state respondents. Stop. Prayer is allowed list after 2 weeks. Yes.
I would like.
May I please, Your Lordship?
Hmm.
I beg to mention item 14.
Hmm.
Your Lordship, we are yet to receive instructions. So if Your Lordship may kindly fix this matter after 3 weeks. Time for respondent
You're appearing for R4.
4.
Okay.
I'm still on behalf of my senior Joshua Shakib.
Okay. Learned counsel for the petitioner, Mr. Such and such present. Stop. Learned counsel, such and such appearing for respondent number 4. Prays that he may be allowed
3 weeks.
3 weeks time to receive instructions and to file the affidavit in opposition. So learned senior government advocate, Mr. K. Angami is present. You have filed.
Not yes.
And
But
you,
main party is AG.
okay. And
3.
okay. And also has a similar prayer and to list the same after 3 weeks. Okay. List after 3 weeks.
Much please.
Please, Lordship, I beg to mention item number 24.
Hmm.
I pray that this matter will be listed after 2 weeks as my senior is out of station.
Learned counsel, Ms. Mendocino makes a mention on behalf of the senior counsel of, you are for the petitioner?
I'm for respondent number 7.
Respondent 7. Who is your senior?
Sir Sidi Jamir.
Okay. On behalf of her senior, Mr. Siti Jamir, to list the matter after
2 weeks.
2 weeks, as the leading counsel is out of
Out of
station.
station.
Out of station. Stop. The prayer is not opposed by the learned counsel for the petitioner, Miss Such and such. Accordingly, list the matter after 2 weeks.
2 weeks.
You're appearing for?
Respondent number
Learned
8.
counsel such and such appears for respondent number 8. Okay.
I also like to mention item number 12. I pray that 2 weeks time may be granted to file affidavit in reply, affidavit in opposition for the private respondents.
Okay. That would be respondent number?
For all the private.
For all the private
Oh,
respondents.
okay. Learned counsel for the petitioner, Mr. Sentilong is present. Stop. Learned counsel, Ms. Mendocino appearing for respondent, all the private respondents. Prays for? How
2
much
weeks time.
2 weeks time to file the affidavit in opposition. Stop. Learned government, senior government advocate, Mr. N. Nangami is present.
I have 5.
You have filed. Okay. So list after 2 weeks. Yes.
Much.
the supplementary cost list for motion. Item number 28.
May I please, Your Lordship?
Yes.
Lordship, 482 application for grant of pre-arrest bail in connection with Kohima North PS case number 40/25, registered under section 3162, 318, 2 and 3 BNS. Lordship, FIR is in page 12.
Yes.
May I read?
Mm.
With all due respect, I, above named complainant, would like to inform you that I am the permanent resident of the aforesaid locality and a businessman by profession, that I have a good relation with one Ahmed Hussein Tapadar, who is a permanent resident of Karimganj and presently residing at Kohima for his business. On dated 14/9/21, my friend Ahmed Hussein Tapadar has invested money in the business of the accused person in the name and style of Royal Bricks Industry situated at village Nalwa Kamalpur, PO Jalal Nagar, PS District Karimganj. Later on dated 25/9/2021, I met my friend Ahmed Hussein Tapadar in a social gathering and started talking about each other's well-being as well as business. Then my friend told me about his investment of some money in the above mentioned brick industry. He said that he had invested a sum of rupees 5,50,000 only for 1 year in the brick industry of the accused person, namely Rashid Ahmed Chaudhry. And the accused had agreed to give him 1 lakh pieces of bricks or the market value of 1 lakh pieces of bricks upon completion of the term 1 year. That upon further discussion, I have also shown interest in investing some money like my friend. So he called the accused person over the phone and I discussed the terms with the accused persons that I will invest rupees 2,70,000 only and the accused person will give me 50,000 pieces of bricks or the market value of 50,000 bricks on the completion of 1 year period. And the accused person will provide me an agreement for the same as they have provided to my friend. Later on 24/10/2021, I gave my friend rupees 2,70,000 in cash to give to the accused person as agreed. And thereafter on 25/10/2021, my friend transferred 2,70,000 through bank transfer into the bank account of Zakir Hussain Chaudhry, as he was the agent of Rashid Ahmed Chaudhry, sole proprietor of Royal Bricks Industry. That thereafter, I and my friend have tried numerous times to communicate with them, but to no avail. The till date, the accused person have not paid me any money, nor have they have given me any bricks as agreed. In view of the above, it is clear that the accused person have criminally conspired against me and have committed fraud and breach of trust with the intent to never return the money. Therefore, I humbly pray before you to take appropriate action and register a case against the accused person under the proper section of law. Thank you. Now, my lord, I, Zakir Hussain Chaudhry, the petitioner here. So, my lord, I was just a witness, like in the transaction that Ahmed Hussain Tapadar made the payment through me to the accused person, Rashid Ahmed Chaudhry, who was the sole proprietor of the brick industry. Now, my lord, I did not have any wrongful intent on my side. Here in the FIR also, there is no mention of any wrongful intent or wrongful gain from that I have made. It was solely the brick industry owner, Rashid Ahmed Chaudhry. I was just a witness. Then thereafter, my lord, I got some.
Yes, Learned Counsel, this criminal petition 2 of 2026, is it still pending?
Yes, my lord.
Is it with regard to the same case?
It is an NI case filed by Ahmed Hussain Tapadar.
No. Criminal petition 2 of 26.
Yes, yes.
You are the petitioner here also.
Yes, my lord.
Here, Zakir Hussain Chaudhry.
Yes, my lord.
Is it with regard to the same case?
My lord, actually, Zakir Hussain Chaudhry paid 5,50,000, and this person, Wellhouse, he paid 2,70,000. That is another amount. So that amount also was.
Okay. So in this criminal petition, this Rashid Ahmed is the complainant.
Rashid Ahmed is the main accused.
No. Criminal petition, he is the informant, isn't it?
No, Ahmed Hussain Tapadar.
Okay. Oh, okay. Ahmed Hussein Tabadar. And in this FIR, who is the complainant?
Complainant is Velhousi, friend of Ahmed Hussein Tapadar. My lord, here also same story. Actually the brick industry is owned by someone else. I was just a medium to transfer the money. It is not alleged that I have not transferred the money to the accused persons. I have already done my part. There is no debt on me. And moreover, my lord, when I received an 41 CRPC notice from Kohima PS, I have promptly replied to them, which is annexed in page number 14.
Okay, we'll issue notice at this stage. Let's see.
My lord, interim may be granted since I was on transit bail for just 15 days and it is over.
When is it expiring?
It already expired on 14th.
Yes. Yes.
Transit bail order is on page 17.
The next date we will protect him. The instant application under section 482 of the BNSS has been filed by the petitioner praying for grant of pre-arrest bail in connection with Kohima North PS case number 40/2025 registered under sections such and such. You just see from the cost title. Okay, stop. Parahard Learned Counsel for the petitioner, Mr. Such and such. Your name?
You can, my
You-
lord, my name may be reflected in the cause list. It is in the
Okay.
local number.
Khan. Stop. The case of the petitioner is that an FIR has been lodged against him at the Kohima North PS, being case and registered as case number 0040/2025 under section such and such of the BNS. Stop. It is the case of the petitioner that he has been falsely implicated in the present case, and that the case arises out of a purely commercial transaction relating to an investment in a brick business run by the main accused, Mr.
Rashid Ahmed.
Rashid Ahmed Chowdhury. Rashid Ahmed Chowdhury. Stop. The petitioner also submits that by where is the transit bail order?
Transit bail order is with me. Page 17, my lord.
By an order dated 30/3/2026, the petitioner has been granted transit bail by the Chief Judicial Magistrate Sri Bhumi, SRIBHUMI, Sri Bhumi. Stop. And the same has already expired on the 14th of April. 14th of April, is it?
Yes, ma'am.
Already expired on the 14th of April. Stop. The petitioner therefore prays that he may be granted pre-arrest bail in the instant case. In the instant case, yes, stop. Para, issue notice returnable on when? 10 days. 10 days.
Yes, 1 week's
Yes.
time.
Okay. Returnable on
My lord, kindly fix a date.
today's, wait.
Next Thursday.
Next Thursday, 23rd.
Okay, ma'am.
Returnable on 23rd April. Okay, stop. Learned PP, Miss S. Mary has entered appearance on behalf of the respondents. Stop. The learned PP shall obtain the updated case diary on the next date. Stop. Till the in the event of arrest of the petitioner before the next returnable date, stop. It is directed that the petitioner shall be released on ad interim pre-arrest bail on executing a bond of rupees 20,000 to the satisfaction of the arresting authority. Stop. List on 23. Yes.
Oblige, ma'am.
For admission, item number 1.
Previous lady.
Hmm.
Here, the department, we are preparing a cabinet memorandum to be placed before the cabinet for consideration and direction. So, my lady, I pray that 6 week time may be granted to us.
This is for regularization.
It's for payment of a minimum scale of pay as per the regular grade 2 DB along areas.
Yes, it is being considered, means,
Yes, we are going to prepare now the cabinet memorandum to be placed before the next cabinet meeting for consideration and direction.
okay. Learned Counsel Ms. V. Shukri appearing for the respondent number 5.
1, 2, 3, and 5.
1, 2, 3, and 5 submits that which department?
The Home
That
Department
Home
as well as,
Department
yes,
has prepared the cabinet memo, and the same will be put up before the cabinet for approval to consider, has
For
prepared the cabinet
consideration.
memo for consideration of the petitioner's case.
and direction.
Petitioner's case for granting of what was that?
It's at page 67, para 15.
67. For granting of minimum scale of pay, which is being paid to the regular grade 2 DBs along with arrears, and the same will be put up to the cabinet for approval. And for this exercise, the learned counsel prays that she may be allowed 6 weeks time. Stop. Learned counsel for the petitioner, Ms. Minusin, is present and has no objections. List after 6 weeks. Yes.
Much.
For admission, item number 2.
This one also, earlier submission was that they are being considered.
Your
Any
Lordship,
positive information?
Your Ladyship, I was informed that it is still with the PNF. Your Lordship, this is a regularization of a contingency night chowkidar at Fazali College, Mokcho. So he was missed out when the district level verification board was taken up. So
Served for 33 years.
yes, now this time it has been done. It has been done, and it is with the banner and banner. So your Ladyship is will our go to finance. From there, it has to go to the state cabinet. So it takes time. And one thing why it is taking time is they have chosen it in a bulk way, all Nagaland way. That means all the departments of the this casual employees. So that way it is taking time.
Consolidated along with other.
I'll read others. That is the thing. That is why it is taking time. So if my learned
But
friend
you have to
increase,
give a specific timing.
if my learned friend
Yes.
increase, I will be allowed some more time. Maybe June, July will be done. I have very hopeful anticipation.
Yes.
Your Lordship, if
Mhm.
till June, till June, since actually.
Okay, 2 months. We'll say 2 months.
Let you.
Learned counsel for the petitioner, Ms. Kim Penyu, is present. So, learned counsel, Mr. Moy Imchen, appearing for the respondent number
Leadership aim for 1 in 3.
1 and 3, is present and submits that the case of the petitioner is being considered for regularization along with similarly situated persons from other departments, and the matter is being taken up in a consolidated manner, and it is now pending before the Department of PNAR. So he submits that the entire process will take another 2 months. So accordingly, praise that it may be listed after 2 months. So, list after 2 months is grateful.
For admission, item number 4.
There is Malidi.
Yes.
Malidi, in here the petitioner 2 and 3, well, the petitioners, the counsel for the petitioners have withdrawn and they've just given the file to the petitioner.
Oh,
And the
okay, okay.
petitioner number 2 and 3 has engaged us.
Okay.
It is an NOC by the
Okay.
counsel for
So
petitioners.
earlier, Diakrolo was appearing. Yes.
Excellent one. And
So they have withdrawn. They have
They have
withdrawn
given, no objection to appoint another
to
counsel.
appoint another
It is
counsel.
only very now.
Oh,
No objection.
okay,
to the filing of power today.
okay, let's see. Learned Counsel, Mr. Fosiko Fote, submits that, um, the previous counsels, Ms. Diakrolo and A. Mason, have withdrawn from the case and have given the no objection certificate for him to appear on behalf of the petitioners in this case. So according, have you filed your vakalat nama in that case?
We file this morning.
Okay, and therefore he submits that he has already filed his vakalat nama this morning. So. Okay, on the earlier occasion, the petitioners prayed for filing a reply to the counter affidavit of the respondent.
You give time to file reply.
Mr. Fosiko Fote also prays that he may be given another, how much time? 3 weeks time to file a reply to the counter affidavit of the respondents. Stop. List after 3 weeks as prayed for. Learned Counsel, Mr. Moa Jamir is present for respondent number.
The sole respondent.
Okay, for the sole respondent. Okay.
Hello.
For admission, item number 5.
One more last occasion the final
Yes.
report was called for.
Notice is complete.
Yes.
Trial court records have come. No. Sorry. Learned Counsel for the petitioner, Mr. Moa Jamir is present. Learned Counsel, Miss appears for respondent number 2. The others are not represented.
Not represented. We have filed a affidavit of justice service.
Okay. Oh, yes, yes. None appears for the other respondents today also when the matter is called. Stop. Para. It is seen that the trial court records have also not been received. Stop. The registry is directed to send a reminder to the Civil Judge Senior Division.
Yes.
To this Civil Judge Senior Division, Bokchung, to send the trial court records at the earliest. So list after 3 weeks.
For admission, item number 6 and 7.
May I please, Your Lordship?
Yes.
Your Lordship, in item number 6, Your Lordship, I've received an instruction that the state government has already released, Your Lordship. However, they are unable to contact the petitioner as well as the counsel for the petitioner. And therefore, Your Lordship, I already gave them.
Lordship, I've got instruction as far as item number 6 is concerned, Lordship. Your Ladyship, we have received the amount of 2,54,000
Okay.
yesterday.
And the other case?
Not yet. I've been informed that they cannot pay.
Yes, Your Lordship, in this item 7, Your Lordship, I received an
The
instruction
amount,
that.
the amount is too big, 6 lakhs.
No.
For the next
This is a
year.
contempt matter. How can you say cannot pay? Okay, first thing, first, let us dispose of the 6th then.
Item number 6, yes, Lordship. I've received it.
Item 6, you say Learned Counsel for the petitioner, Mr. Ed Mosey is present. Stop. Learned Counsel submits that he has received the amount of rupees. How much was it?
2,54,700.
4,753, which was the pending bill amount due to him. And therefore, he prays that this matter may be closed. Stop. Accordingly, the case is closed, the matter is closed and disposed of. Okay.
Your Lordship, our name
Your
is reflected.
Okay, okay.
I am for respondent
Learned
number one.
counsel at the bottom, you say Learned Counsel Mr. N. Nangami appears for respondent number 1 and Miss Livika
For 2, 3, and 4.
1 and 2, 3 and 4. Okay. Then COP 34.
Yes, Your Lordship.
Yeah.
In COP 34, Your Lordship, I also received an instruction, Your Lordship, from respondent number 4 that the fund does not comes under that department. It falls under PHQ. That's why they have given a direction, Lordship, to the PHQ to consider for compliance. And yesterday, Your Lordship, I got information that the matter has already been put up, Your Lordship. So another 3 weeks will be granted, Your Lordship.
How to kindly appreciate, respondent number 4 is the chief engineer of the police.
Yes, Your Lordship.
They cannot say they don't fall under the PHQ. They are part and parcel of the PHQ, Lordship.
Your Lordship, we have received instruction. I couldn't able to place that letter, Your Lordship, because I only received the soft copy only. So it seemed that the fund falls under MOD 2015 and 16. So it's completely under the jurisdiction of PHQ. And therefore, they've given a letter, official letter to the PHQ, Your Lordship, to the DGP, Your Lordship, for compliance. And yesterday, I got an intimation that matter has already been put up, Your Lordship.
So even respondent 3 is also the DGP.
No, just number 4. I got a letter from respondent number 4, Your Lordship. And for number 3, letter has been sent to number 3, Your Lordship.
The council is representing number 2.
So you are representing 3 also, isn't it?
Your Lordship, that's why, Your Lordship, that's why, Your Lordship, I am giving an information the matter has already been put up, and therefore, Your Lordship, another 3 weeks will be granted, Your Lordship. That is my humble
They put up to the DGP.
Yes, Your Lordship, it has been put up, Your Lordship.
So they're saying for payment. They're saying they're
yes, it's for payment. Yes.
Apparently, they're communicating among themselves, Lordship.
No, whatever.
No, because an official letter, Your Lordship.
Maybe they are saying that the funds are now with R3 and R3 will pay within 3 months, 3 weeks, isn't it?
Your Lordship, it has been put up.
No, we'll see. Let's see. Learned Counsel for the petitioner,
As a last transfer.
Jose is present. So, Learned Counsel Ms. Livika appearing for respondent number 2, 3, and 4. Submit. But then that letter is not before the court. No.
Yes, Your Lordship. I also got only the soft copy. Just few days back only I got the letter, Your Lordship. That's why, Your Lordship, the hard copy is yet to reach me, Your Lordship. That's why I'm unable to place it before.
The matter has now been put up to the respondent number 3 for payment of the pending bills, as the funds would be with the PHQ, as the funds are with the PHQ and not with the chief engineer, police engineering project. Stop. And he further praised that she may be given another 3 weeks time to release the payments. Stop. Learned Counsel Mr. N. Nangami appears for respondent number 1.
May I pray that
There's a lot. Yes.
if no payments are made of the 3 weeks, Lordship, interest may be imposed, Lordship. Because my money has been
We'll see on the next date. We'll see list after 3 weeks. Yes.
Obliged.
Much obliged.
For admission, item number 8.
Actually, this is for disposal, final disposal.
Okay.
Admission.
Admission hearing. Okay. Yes.
Yes. Should be Deputy Commissioner Limanfano, acting as a revenue authority, has decided that the land on which my approach road, on which I have constructed my approach road to my residence, is not a private land belonging to me, but is a public road. And this has been done at the instance of the complaints filed by the respondent number 4 and 5. My case is Malotso. My case is that it deals, he has adjudicated the deputy commissioner as a revenue authority, has adjudicated on the rights ownership of an immovable property. He has adjudicated a dispute relating to rights over a immovable property, land. He has no jurisdiction to do so. That is my case. Only the civil court can decide the matter. That is the crux of the matter. My lady,
What are the facts?
may I just briefly narrate the facts
Yes.
first, then take your honorable court through the documents. I bought a land from one Orange Match and John Moy Match in the year 2010, measuring about 3 acres in Utumbukri village. After the surrounding land also belonged to him, the previous owner. So they gave me an approach road to my land. On both sides of the approach road, the land of the previous owner was there. Now, this land also was sold in 2011 to another person, one Mr. Felix. He was not given the land, the approach road belonged to Match. He did not sell the land, the approach road, but the right to use the approach road was also given to the person, Mr. Felix. Now, Mr. Felix wanted to encircle the entire land, but the approach road to my residence ran right through his land. So therefore, he could not encircle the land with the boundary wall. So he made me an offer in 2012, saying that I'll give you alternative land on the site to have an approach road to your building, to your residence. Initially, I refused because it was a longer route and with many curves. But he said, I'll give you, now your approach road is only 18 feet, I'll give you 21 feet. And accordingly, I agreed. That was in 2012. Then afterwards, he sold all this land to the respondent number 4's husband. And the respondent number 4 also bought some other adjoining land. And they have constructed the residence as well as a school. Now, in 2012 itself, before they had purchased the land, I constructed the road. I laid down culverts, boundary, road markers, and I spent about 6 lakhs. Now, they are claiming that then I allowed pedestrians to use the road. Now, this road is behind the school. So they want an entrance there. They have an entrance also behind the school. Now they were using this road. I did not object. When vehicles started plying on the road and damaging the road, then I objected. But since it was not, they did not listen, I set up a gate. That's when they filed a complaint with one of the neighbors, that is respondent number 5, claiming that this is a public road. And this order was passed.
And who is respondent 5?
Respondent number 5, 4 and 5. 5 is another neighbor.
They are a complainant.
Oh.
They are the complainants, a neighbor. 2 of them, 4 and 5 together filed
4 and 5 filed the
together
complaint.
filed the complaint.
Let's see the impugned order.
Yes. Page number 26. Merlin McCully is dated 15 April 2025, and it is a case which is the respondent number 4 and 5 versus the petitioner. May I read this?
Yes.
Whereas this office in receipt of the complaint application dated 39/2024, wherein the complainant Srimati so-and-so and Srimati so-and-so had allegedly claimed that respondent number so-and-so had constructed a gate on a road intended for public use, thereby causing illegal obstructions and inconvenience to the public who use the same. And whereas taking cognizance of the dispute, this office directed Office of the DLSRO to conduct spot verification, submit this report number dated 3/10/24. As directed, the DLSRO, by letter number such, submitted the said report. And whereas, in continuation to the proceedings, the party concerns were summoned and hearing was conducted on 6/3/2024. After hearing the parties, After hearing the parties put forth their respective claims and counterclaims to determine whether the gate was constructed by the respondent number 4 falls on a private or public road. Apart from their oral submission, the parties also relied on documentary evidence and witnesses. On conclusion of the hearing, the matter was adjourned with the direction to the parties to submit the gist of argument on or before 13th 2025. As directed, the parties filed the gist of arguments. However, when the matter was thus situated, Mr. P.S. Felix approached the office and filed a detailed affidavit averring the substance of the dispute. Therefore, this office found Mr. Felix to be a material witness whose examination was deemed germane for determining the facts in issue. Accordingly, on 29/3/2025, Mr. Felix was examined as a witness, thereafter discharged after cross-examination. My lady, may I just pause here for a moment? This person appeared after the conclusion of the hearing by filing an affidavit, and so he was admitted. My lady, he was not examined per se as it is to be done, not on oath. He appeared to visit. I was also asked to given some opportunity to make put some questions, but it was done through VC. Nothing was recorded. His statements, which were also in my favor, has not been recorded, and the network also was poor, so examination also could not take place properly. But it was not on board. And another thing, my lady, is that I also requested that the village council, who was seized of the matter, who knows about the matter, be examined, but that was also refused. In my gist of argument itself, in my written, which is taken as the written submission, there also I have mentioned, but that opportunity was not given. During the argument, the respondent allegedly claimed that there was an approach road leading to his plot of land measuring 3 bighas under Pata number such, which he has purchased in the year 2010 from that foreign son. However, in the year 2012, Mr. Felix purchased the land over which the approach road runs from two different individuals. Therefore, Mr. Felix approached him with a request for exchange of the approach road, to which he agreed. And accordingly, Mr. Felix carved out a present disputed road from his plot of land. In support, the respondent produced a land exchange agreement registered before a notary public wide registration number such dated 1/10/2024 that is purported to have been executed between him and Mr. Felix. Per contra, the complainant submitted that the approach road leading to the respondent house was a public road that was being used by the residents of the locality and the parents, teachers, and students of Milan School. In this regard, it has been submitted that when the complainant, Mr. Birmingham Kikon, husband Molano Kikon, purchased his essential parcel of land from Mr. Felix in the year 2015, there was already an existing road that is the disputed road. This disputed road, measuring approximately such 440 into 20 feet, as per the statement of the complainant, Srimati Sonso, had been voluntarily allotted by Mr. Felix in the year 2012 without any consideration or compensation sought from beneficiaries. Further, the complainant, Mr. K. Aranla, also submitted that she has contributed some portion of her land to facilitate the approach road's expansion. Say Felix, the witness in the instant case, deposed that in the year 2011, he purchased a plot of land measuring 2 bighas under Pata number such, Moja number such, from Sonso. Adjoining this plot of land, he again purchased a plot of land measuring 4 bighas under Pata number such, from Helen Mesh in the year 2012. After merging the two plots of the land, he sold the same to Mr. Sonso in the year 2015, and disputed road fell under Pata that was sold to him. He categorically stated that the existing road is the disputed road has been freely donated by him for the benefit and convenience of all residents of the area and the respondent, and that the respondent or any other person should not have any right to claim the existing approach road as individual property. Further, as regards the land exchange registered before a notary wide registration number such that is such, he denied that the signature appended to the said deed was his signature, or that there was an exchange of land that took place between him and the respondent for an approach road. On the contrary, Mr. Felix reiterated that the approach road over which the gate has been constructed by respondent number 4 was donated by him for the benefit of the residents of the area. I have heard the oral submission made by the parties at land, peruse the case record placed before me, examine documents relied by the parties, and the spot verification submitted by the RSO. Now, taking into consideration the fact mentioned above, I am to opine that for respondent to establish the disputed road cadastral area as private road, the same should fall under his Pata land. No doubt the respondent had ostensibly claimed that the approach road is a private road through authorized land exchange agreement executed between him and Mr. Felix. However, shown above, this claim has been recorded cogently by Mr. Felix prima facie. Even if the land exchange agreement has been duly executed between the parties, the same cannot come to the aid of the respondent as a date of exchange. Immovable property ought to have been registered before a sub-register, paying the requisite stamp duty. Further, meticulous preparation of the spot verification report submitted by the DLSRO depicts a scenario wherein the respondent is in excess of 14 lectures. At present, his possession is 3 because 14 lectures, though the area mentioned in this pata is 3 because before bifurcation. Furthermore, it is noted that the distance from the respondent land residence and the gate is 440 feet and does not fall under pata numbers such as such, that number such. As such, without any further documented evidence to prove it otherwise, it can be said that the gate has been constructed on the approach road does not fall under private land. Now, therefore, this hereby directed the respondent remove the dismantled gate and dismantle the gate that came up on the approach road and thereafter vacate the same within a period of 15 days from the date of passing of this present order. Failure to comply with this present order may have legal consequences. So, my lord, this is the order. Now, lordship, he says I'm in 14, excess of 14 acres. This is regarding the land within my building complex, within my complex. Pata is for 3 because, but I have 14 acres extra. This is not a dispute in this case. The road is not within my complex. He's saying I have 14 acres access within my complex. Access in the case that only 3 because is mentioned in the pata, I have 14 acres. But that is not the disputed subject matter of the dispute. The dispute is relating to the road. Now, Felix says, I have not signed an agreement, an exchange agreement. Now, what happened when the dispute came out? There was nothing in written. So I called him, and he was in Ukhrul. And he said, I cannot come, so you draft an agreement and send it to me through WhatsApp, which I did. Then he said, I cannot come, so you let my brother sign it. And in the affidavit he has filed before the Deputy Commissioner, it is mentioned that his brother has signed on his behalf. Anyway, my case is whether the Deputy Commissioner will have jurisdiction, because this is a dispute relating to land. One is claiming this is a public road, and another is saying it's my land.
You're claiming it's within your land.
It's my land. I'm claiming that it's my land. I had given, this was given to me by Felix in exchange for the road that I had foregone. Now, my lady, if when the complaint went, the respondent went and filed a complaint, and the Deputy Commissioner decided that the land belongs to public, that means belongs to the state, public road. Now, my lady, there's another angle to it. If I'm an illegal occupant of the public land, if the land is a public land, my lady, if I'm an illegal occupant of public land, then the law is the Eviction Act. We have our own Eviction Act.
Yes.
Under that, the process should take. And under that, my lady, the Deputy Commissioner also has the power under the CPC to call people, summon people, and examine them on oath. But again, my lady, the Supreme Court says when there's a bona fide dispute, the government also, the state also cannot unilaterally decide the matter by invoking the Eviction Act. It has to go to the civil court. So therefore, this is a fit case which can only be decided by a civil court. That is precisely my case, my lady. My lady, now just through the, let me just take the Honorable Court through the documents. Section 2 is the salary.
Annexure 2.
Annexure 2, page 30. My lady, may I not relate? This is the land that I bought from the Mr. Match.
This is the same.
Yes, this is in 2010. Then my lady, may kindly come. Page 33 is the summon. No, this is the mutation order. Mutation order. Then my lady, may kindly come. Pata. After this, I was given pata. 3 because initially came under 1 pata. but I separated 1 bigger so that I could take loans. So I made 2 parts subsequently, page 34 and page 14. My lady, then page 46, this is, even here I would like to point out one fact, my lady. This is the declaration by Horan Match through declaring the sale of land to Mr. Felix. My lady, can you just see paragraph number 2? That I sold the said land from Patan number search, measuring the total area of so in my name, and the said land was sold, including the right to use the approach road. So therefore, a land. This is clearly shows that there was an approach road. This approach road was an approach road to my building. So this land was not sold to him, but the right to use it was mentioned. Now, my lady, page 49 is the summon. Then page 50 is the written statement of the complainant. Here, my lady, may kindly come. They have enclosed certain sort of a map at page 55. I would like to point out a few things here. You describe, you get given a description. May kindly come to A, illegal gate constructed by Mr. Tupochoki. B, care unless land taken by October for road expansion. See, my lady. Okay. I had in my written petition all along. B, may I just pause here for a moment? All along, I had said that when the road was constructed, my lady, may just yes. When the road was constructed, the road was touching this response care Aranla's septic tank. So she objected. So Mr. Felix said, "I'll give you little land, you allow, and I'll reconstruct your septic tank." And accordingly, she agreed. Her septic tank was shifted. And she was also given a little bit of Mr. Felix gave her land, and accordingly she accommodated. So she gave some land for my road. Then again, C, then given by CCOM for road expansion from middle school property. So they also gave certain road land. Adjustments were made. D, land given by again for road expansion. E, land given by Sansa for road expansion again. F, this is important. Land taken by Mulamo from the road to make the wall straight. See, my lady. Again, how could a public land be taken this way from the road? It cannot be taken. Adjustments were made between the petitioner and the respondents so that the road could be constructed. I also gave a part of my land, and this is how the road was constructed. Then, my lady, may kindly come to.
And where did you put the gate? Gate is at
near Aranla's residence, because this road, this approach road starts from this Aranla's residence. Then it leads only to my house. It leads only to my house. And
no, but your land is right at the bottom.
Yes.
How can this whole thing starting from A? This whole thing, how can it be
along the road? They have given this along the road. A is where the gate was constructed.
That's what I'm saying.
B is the land where adjustments were made with Aranla.
This approach road crosses everybody's land.
Yes.
And your land is right at the bottom.
At the bottom, yes.
Then how can you say that this whole road is your land?
My lady, this approach road was given to this land because earlier this road, they all have their entrances. So on the other side, this Mulnamo residence, your lady may kindly see the Mulnamo residence. This land belonged to Felix. And my lady, they have not included in the map the original approach road ran right through this Mulnamo residence.
Okay.
So therefore,
earlier,
the approach road that I mentioned earlier in the self declaration also. So now they cannot build a wall encircling this land because there is an approach road leading to my land. So this arrangement was made with me.
Okay, and then?
Then, my lord, these are the page 56 is my written statement. Here it says the same thing I've said, my lady. Then this page 59 is the summon after Felix appeared. Now, my lord, may kindly come to page 60. Is the affidavit by Mr. Felix. My lady, may I kindly from the paragraph 4, relevant portions, that in the year 2015, after merging the two plots with the boundary wall, see, my lady, this land was merged by building. That was possible only when I was given that alternative approach road. I sold the said property in Mulnomokiko. The approach road in question is covered in the same pata that was legally transferred to him as a part of the sale. My lady Mikali, this is very important. He says he sold the land. The approach road also is part of the land that he has sold. That's what he's saying, my lady.
Yes.
He's saying that very clearly here. Then in the year, next page, my lady, please. In the year 2024, Atopi Chopi approached me stating that implying that the approach road may encounter certain issues with Monlambo Kikon and therefore requested a written agreement regarding the approach road donated by me. As I was unaware of the specific nature and issue he was referring to, I sought to clarify my position that the said approach road was donated by me for benefit of the residents in the area, enabling to them to access to an approach road. That it has come to my attention that the land actions has been properly executed by Sierra Trophy, exerting that I agreed to a change of my plot of land for the purpose of constituting the existing approach road in the year 2011. However, I categorically state that I purchased the mentioned plot land in 2 different years, this is 2011 and 12. Therefore, the claim made by Atipo Trophy regarding my alleged concern in 2011 is false, misleading, and without any basis in the fact as the construction of the boundary wall of the said properties and donation of the approach road by me occurred in 2012, which I'm also saying, man. Then my name is 7. Since I was out of station at the time, I requested my brother to sign the affidavit on assuming that Sri Atopo Chopi acting in good faith would accurately reflect the fact that the approach road had been donated by me for the benefit of the adjoining residents. So he admits that he asked his brothers to sign the land exchange agreement. But however, I'm shocked and appalled to learn that affidavit misrepresents the fact by falsely implying that there was a land exchange between Atopo Chopi and myself. I can really state that land in question belonged to me prior to its donation for the approach road. And at no point of time there was any agreement to exchange the land with any party for the said road. Any selection of the land exchange is false, misleading, and without basis, as the approach road was freely donated by me for the benefit of all resources. Moreover, in the pertinent to note that Mr. Chopi approached me for the said affidavit only in the year 2024, further contradicting my prior claim of exchange. 8. I hereby declare that the existing approach road at Porto Bukli Measuring University, measuring such and such, is freely donated by me for the convenience of the residents. My lady mechanic policy. Here, now again, it's different. Earlier he said he's solid to respondent number 4. Paragraph 4. Now he is saying it's donated. Look at the inconsistency. I freely donated my plot of land for the purpose of constructing an approach road for the benefit and convenience of all residents of the area. Seattle fortunately on any person had no right to claim the existing road as his individual. So this was basically his step. He said that he's donated. But here in this same affidavit, he said he has sold it. And subsequently he said that is either sold or is donated. Anyway, the point, since we are under a read petition.
He said it was sold and that the approach road was in that same pata.
Yes.
Which was sold to Mr. Swikon.
Now, my lady, these are basically the facts. Now, DC, which influences mine is that this land is not reflected in the pata. Therefore, I have no right. So, my lady, my first point is revenue entries in revenue record alone cannot decide rights. Other issues are important. And he said that land exchange document that has not been registered, but it can be used for collateral purposes such as possession. How did I construct the road then? How could I construct? They are not disputing that I have constructed the road. Can be used for that purpose. So there involves disputed questions, a lot of disputed facts, which can only be decided through an appropriate trial in a competent civil court. Even the Eviction Act, yes, if I'm an adverse malady, they can proceed against me under the Eviction Act if it's a public land. Follow the due process. Basically, that is my case, my lady. May I just submit my lady, there
Yes.
is another thing. Village council. Village council. My lady. Village council. I requested, I even get in my written statement that the village council should be called. Now, village council. You may kindly see paragraph, section 12. 1. The section 12. The village council shall have the following powers and duties. Page 6. If, I don't know whether it's
Page 6,
page 6.
section 12, yes.
The village council shall have the following powers and duties. To formulate village development schemes, to supervise proper maintenance of water supply, roads, power, forest, education, and other welfare activities. So the village council is the right authority to know about this, whether this is a public road in the village or not. But they were not allowed, they were not given, I was not given an opportunity to bring them and give evidence, or at least section 15 again. We just read, no transfer, G.
Yes.
No transfer of removal property shall be effected without the consent of the village council. Written record of this shall be maintained by the village council. So they are within the village, they will know everything. But these persons were not even examined. Yeah, that's what you know.
Okay.
Now, my lady, there's
Yes.
no, may I just refer to the affidavit in opposition.
The state respondents affidavit.
Yes, my lady. The first, the government's affidavit state respondent number 1, 2, and 3. In paragraph 9, my lady, that paragraph only.
Paragraph
9. That with regards to the statement made in such and such, that is petition, the same the petitioner's narrative on how he allegedly claiming the road to be his private road. It is stated that the survey report submitted by such and such, there is also explicitly shows that the length of the approach road stating from the gate constructed the petitioner, Siatabu Chopi, and his resistance is 400 feet and falls under 4 partners. Kindly note this 4 partners, that number, 4 drafts, that number 259, 264, 268, and 265. Now, in the affidavit by the private respondent, at page 4, paragraph 5A, the approach road measuring sources, paragraph 5A.
Yes.
The approach road measuring sources is covered by under pattern number 6, that number 263. Doesn't tell you what the government says also. That number is also different.
Number 263.
263 is not there in the as per the survey report. So, there are a lot of disputed facts. The revenue authority cannot decide this matter in such a manner. Well, yes, no. May I just now listen authorities. First one is 2021 SEC online A02. And they have also submitted submitted a list of authorities for the convenience of this honorable court last week. Paragraph 8 and 9. In paragraph 8.
Okay.
Paragraph 8.
Yes.
In the case of such and such, those says also, it is observed that and held by this court that any entry in revenue record does not confer title on a person whose name appears in the record of rights and entries. Entries in the revenue record as Jamabandi have only fiscal purposes, payment of land revenue, and no ownership is conferred on the basis of such entries. It's further observed that so far as the title of property is concerned, it can only be decided by a court, competent civil court. Similar view has been expressed in such and such and so on. So 9. In view of the above, the settled proposition of law laid down by this court, it cannot be said that the High Court has committed any error in setting aside the order passed by the revenue authorities directing to withdraw the name of the petition therein, the revenue records on the basis of the alleged will with the substances and relegating the petitioner to approach the appropriate court to crystallize his right on the basis of the alleged will with such and such. We are in complete agreement with the view taken by the High Court. Therefore, my lord here also involves ownership over the land. So this can has to be decided. And my lady, the next one is 2007 4 GLR. My lady, paragraph number 9. May I read this? The alleged admission of the plaintiff on which heavy reliance was put by the learned trial court is that, in fact, its purpose finding, inasmuch as the plaintiff number 1 immediately after stating that the defendant vacated the suit premises such so and so, in such and such has further stated that in the year 72, the amount of March the defendant again returned back to the suit premises. In this type, the vital aspect was left out by the consideration of the trial court and statement of the plaintiff is consonant with the statement made in the plaintiff, inasmuch as the claim of the plaintiff is that the suit premises were taken into rank such. The other consideration of the learned trial court was that the order of the revenue board set aside the mutation order. The order of mutation is only to facilitate the payment of land revenue. Revenue cost is not entitled to decide title in respect of landed property, which is subject matter of the civil court. Again, another one. Similar view again taken in 2012 3 GLT 264 paragraph B. Short one. Paragraph A. In my consideration, the Learned Deputy Commission as well as the Learned Assam Board of Revenue have exercised their jurisdiction by entertaining the petition involving determination of right, title, and interest, inasmuch as such issues should be determined by civil court only, and is the exclusive domain of the civil court. My lady, this another case by Supreme Court. Here, my lady, the government of Andhra Pradesh had invoked the Eviction Act. But
Okay. This is also regarding the title.
title,
Determination
so
of title.
only a suit be
Para 8.
8 and 9. I may not read it.
Yeah.
So, and again, 20 again.
It's
Here
also on the
similar paragraphs 48 and 49.
same proposition.
Yes, same position. Then again, my 2042 SEC same revenue records will not comfort title. Same thing, my lady. And 7 2002 3 GLR civil to adjudicate. Now, my lady, here they are saying that state has said that Assam Land Revenue Regulation section 165, I think. So there's a bar. No, read will not lie. Revenue, no case will lie. But this case clearly says that the Assam Land Revenue Regulation cannot bar the jurisdiction of
The civil courts.
yes, or even this court. My lady, this is we are under 226 constitutional powers. No statute can bar it. Then, my lord, again, it also said to civil court jurisdiction cannot be barred the complicated questions of related to title and law. Then, my lady, the October, Adi Agajanga, Durandra Magazine, I would up to the witches in last.
But 1989.
My lady, this one I have not included in the list of authorities, but this is a case where it's on the court. Where, my lady, even the case there too, the government had Jamabandi in their favor.
and have invoked the Eviction Act. This honorable court says no. You have invoked this after cancelling my Jamabandi and relying on the government's Jamabandi. Therefore, now, this honorable court says, relying on that Andabata case, 1992 case, which I've just placed, relying on this case, this honorable court says, no, they cannot invoke this.
In this relevant para?
Relevant paragraph is 13 and 14. And the government were directed to approach the civil court. If the government claims that this is a public land, they cannot unilaterally decide by invoking the Eviction Act. They have to go, because there's a dispute now regarding the ownership. Now the government has to go and file a civil suit. This was the direction, even in this case. So, my lady, the Deputy Commissioner, and another thing, if you see the impunal, at page 29, you can come, page 29. Right. This is supplementary government. The Deputy Commissioner passed that order rapidly. But all the hearings from the very beginning to till the end was done by the Revenue Settlement Officer. This is just passed the order. But it's just a supplementary. My main ground is that no jurisdiction. Absolutely no jurisdiction to. And if the government says that this is a public road, then the appropriate step has to be.
Revenue officer is also a court within the Assam Land Revenue.
Right.
Revenue officer also can take up.
But, my lady, can they decide the dispute?
No, that is another matter. Yes.
Bless your ladyship. Ladyship, I'll take your ladyship to the state counter affidavit in opposition.
What is your stand?
State counter affidavit in opposition filed by respondent number 1, 2, and 3. This is your ladyship, 2-3 pages only. I'll try to read 1-2 pages so that your ladyship may be able to comprehend the case. And ladyship, let me start with the para 4, page 2.
Yes. Yes.
That with regard to the statements made in paragraph 2 of the writ petition, the answering deponent respectfully states that by issuing the order number so-and-so dated 15/4/2025, which is under challenge in the present writ petition, it is stated that the answering deponent did not decide rights, title, and entries over the road, but simply held that the said route was a public road and not a private route after meticulously perusing all the documents and statements given by the parties concerned. The settlement order was passed not in a mechanical manner, but after careful application of mind and after weighing all available records. Your ladyship, I'll take your ladyship to page 4, para 8. Page 4, para 8. That with regard to the statements made in paragraph 6 of the writ petition, it is stated that the sale date dated 15/2/2015, petitioner's document annexure 6 pertains to alleged transactions made between one Sri B.S. Aten and Sri Foreign Mage, who are not parties in the instant writ petition. As such, the answering deponent offers no comment. Para 9. That with regard to the statements made in paragraph 7, 8, 9, and 10 of the writ petition, the same are the petitioner's narrative on how he is allegedly claiming the road to be his private road. It is stated that the survey report submitted by the district land revenue and survey officer by number so and so dated 18/11/2024 explicitly shows that the lane of the approach rules starting from the gate constructed by the petitioner, Sri Atobo Chobi, and his residence is 440 feet, and it falls under duct, that is duct number 259, 264, 268, and 265. To this end, it is stated that the petitioner's pattern number 1314 is under duct number 263/181, 1811. Petitioner's document annexure 4, and the pattern number 154 is under duct number 2057, petitioner's document annexure 5. Therefore, there is no connection between the petitioner's land, which is under duct number 263/1811, and duct number 2057, and the approach route, which is under duct number 259, 264, 268, and 265. Further, the survey report also mentions that Sri Atobo Chobu is an occupation of 03B00K14L so area mentioned in his land pattern number so. That is in excess of 14 days. A copy of the MIP along with the verification report dated 11/11/2024 is annexed with in Marx's annexure 1 and 2. Your Lordship, your Ladyship, please come to the annexure 2. Annexure 1, that is in page 12, your Ladyship will find. And this spot verification report. May I read it, your Ladyship? Spot verification report.
Yes.
In pursuance to Deputy Commissioner Dimapur, later number so dated 3rd October 2024, I have done the spot verification of the gate constructed by Sri Atobo Chobo along with both parties, that is the Bashis of DC office, Dimapur, at Wadambokri village. And verifying the spot in the statement from the concern, the following observations were made. Number 1, both applicants, that is Srimati Paumibin Kekong and Srimati Ki Arna, stated that the approach road starting from the gate constructed by Sri Atobo Chopi and his residence is not included in the lane Bata. Declarations submitted by them are enclosed herewith as annexure 1 and 2. That is not their Ladyship. 2. Both applicants stated that the approach road does not belong to any individual. It is a public route. 3. Sri Atobo Chobi stated that the present approach route is not a public road, rather it belongs to him. Besides, he stated that he exchanged the present approach road with an old approach road, which also leads to his residence, which belongs to him. The length of the approach road, starting from the gate constructed by Sri Atobo Chobi and his residence, is 440 feet, and it falls under 4 ducts, that is duct number so. Number 5, as per the land bata of Sri Atobo Chobi, area of his residence is so. However, area found to be on the ground so, your Ladyship, submitted with my report for perusal and necessary actions. Report submitted by Mr. So, Surveyor, District Land Record and Survey Office, Timor Leste. Your Ladyship, I'll take you to the page 5, paragraph 10. That with regard to the statements made in paragraph 11 of the read petition, the statement pertains to an alleged amount of money spent by the petitioner in maintaining the approach road, for which the answering deponent have no knowledge. There is absolutely no supporting documentary evidences to substantiate the claim of the petitioner. Ladyship, please turn to page 6. I'll read para 13, which is very pertinent. That with regard to the statement made in para 16 and 17 of the read petition, the statements are false and misleading. It is stated that the petitioner, Pada so-and-so, it is stated that the petitioner at para 18 and 19 of this read petition has made an admission that summons was served on him, and accordingly he appeared for the hearing and also submitted his written statement, case of argument, petitioner's document, and Annexure 9. This explicitly explains that on his own volition, he has taken part in the proceedings without any argument. No mention is made that he has not received a copy of the complaint or the survey report. On the contrary, he has categorically stated in the cover letter while submitting his written statement as submission of written statement with regard to the complaint lodged by Messrs. Paumin Pen Kegon and Mr. Molomo Kegon and Srimati Aranda Au against me on construction of illegal gate in the approach route to Milon School. Page number so and so of the petitioner's read petition, and only defended that the approach route is his private route and not the public route. Your Lordship, page 7, para 15, that with regard to the statements made in para 19 of the read petition, it is admitted that the summons were issued by dated 25/3/2025 for examination of witnesses. Witness, Mr. B.S. Flex, as regards the answering respondent office mentioning proceedings as suit. It is submitted that the same has been inadvertently entered as a suit instead of a case. Para 16, Your Ladyship, that with regard to the statement made in para 20 of the read petition, it is submitted that witness Mr. P.S. Flex appears in virtual mode video conference and only disposed as to the content of his affidavit, petitioner's document, Annexure 11. Therefore, when the petitioner cross-examined him, he affirmed that the present approach rules was donated by him for the benefit and convenience of the residents of that area, and that the present petitioner or any person has no right to the existing approach rule. The witness, Mr. B.S. Flex, also affirmatively answered the petitioner's question that the signature of the land exchange agreement dated 1/10/2024, petitioner's document Annexure 12, has not been appended by him, and it is mentioned that the same would not be reviewed by the petitioner. Page 8, para 18, Your Ladyship, that with regard to the statement made in paragraph 22 of the read petition, it is submitted that the land exchange agreement dated 1/10/2024, petitioner's document Annexure 12, has been disowned by Mr. Flex, and the petitioner failed to review the same during the cross-examination. Further, it is admitted by the petitioner himself that the land exchange agreement was signed by the brother of Mr. P.S. Flex. In this connection, it is noted that nowhere in the land exchange agreement registered by a notary public with registration number so and so, dated 1/10/2024, mentions the same of the brother Mr. P.S. Flex, or that the same has been executed on behalf through power of attorney. On the contrary, the land exchange agreement begins with the residual. Agreement is hereby made between Sri Atobosome and Sri Flex, and appears the signature and name of Flex on the said agreement, as shown above. This act of petitioner amounts to criminal offense punishable under so and so of the Bharatiya Natya Sanhita 2003. Para 19, that with regard to the statement made in paragraph 23 of the read petition, it is stated that nowhere in the unregistered sale date 1/10/2010 mentioned that the present approach road belongs to the petitioner. Further, the survey report dated 3/10/2024, submitted by the LRSO, the Memorial makes a mention that the distance between the gate of the petitioner which is constructed and the petitioner's lane is 400 feet, and the same is not under the duct mentioned in the lane patas of the petitioner. Therefore, no rights as to the approach route, being a private route, can be claimed from the same. Para 20, Your Ladyship, that with regard to the statement made in paragraph 24 of the read petition, it is denied that the right title and the rest over the land on the approach route lies have been decided against the petitioner in the tribunal proceeding, As shown above, apart from the oral statements, no documents have been produced as evidence to prove that the abroad road is a private land. In this connection, it is stated that the revenue courts have jurisdiction to determine the same under the section so-and-so rules, so-and-so of the settlement rules under the Assembly Land and Revenue Regulation, so-and-so. Therefore, no illegality can be attributed to the order dated 15/4/2025. Lordship, your ladyship next page 10, paragraph 22. That with regard to the statement made in paragraph 31 of the writ petition, it is submitted that the signature appended on the imbued order dated 5/15/4/2025 is that of the revenue officer cum resettlement officer. That is the answering respondent number 4. Herein, who has initiated and conducted the proceedings. It will be noted that the sub-divisional officer holds the charge of revenue officer cum resettlement officer and Rule 3, Roman 2 of the settlement rules under Assam Land and Revenue Regulation 1886 empower the Deputy Commissioner to delegate power under Rule 18(1), Clause 1 and Clause 2 to the sub-divisional officer. Worship, that is the short submission on behalf of the state respondent. So, your ladyship.
So according to you, your case is that it was a public road, so no title has been determined by the revenue court.
Lordship, your ladyship. So my only prayer on behalf of the state respondents is this writ petition deserves to be dismissed as being devoid of any merits. Much obliged, your ladyship.
Okay.
May I please, Lordship?
Yes.
Lordship, I'm praying for a number of points by the complainant, Lordship. Lordship, the impugned order dated 15/4/2025 is passed by the Deputy Commissioner Dimapur in excess of the power and jurisdiction under the Assam Land Revenue Regulation, short regulation for short 1886, Your Lordship. So on the issue of jurisdiction, may I take your Lordship to the relevant provision of the regulation?
Regulation, do we have Assam Land Revenue?
Regulation, Assam Land Revenue Regulation, Regulation 123, 123.
123.
Lordship. That will come under Chapter 7,
Yes.
Part 1, Revenue Office.
Powers of officers.
Yes. So every commissioner of the division, deputy commissioner, assistant commissioner, or assistant commissioner shall be a revenue officer for the purpose of this regulation. So who will be the revenue officer? Now next.
123. Yes.
Regulation 140, 140, 140 and 141. I will be relying only on these three.
140. Place for holding court.
Place for holding court. It comes under Chapter 8, Procedure.
Yes.
Subject to the orders of the state government, the board may hold court at any place within the state of Assam, be a deputy commissioner, an assistant commissioner, or assistant commissioner, whether in charge or not of a subdivision of a district, a settlement officer, an assistant settlement officer, or survey officer, such and such, limits of district subdivision to which may hold court at any place within which the limits of the districts or subdivision of which she is appointed. Now, next 141. So these officers will act as a court under 140. 141.
Yes.
Power to summon person to give evidence, etc. The board or any officer mentioned in section 140 may summon, that is the court, any person whose attendance they consider necessary for the purpose of any investigation is relevant, or other business before them conducted under this regulation. But here, Lordship, I admit that so far as title is concerned, Lordship,
That cannot.
the board, it cannot. Now, may I take your Lordship to the complaint? So, under the Regulation 1886, the Deputy Commissioner's assistant or settlement officer, Lordship, they function and sit as a court. May I take your Lordship to the complaint, which I have filed? Page 49, which. So, what was the complaint? Oh, sorry, Your Lordship.
Not
It's not page 49.
It's the summon.
The 24. 24, my affidavit of opposition. 24, I have annexed in my affidavit of opposition.
Okay, let's see your affidavit.
Affidavit of opposition. Lordship is going to 2025.
Okay.
Fine. Lordship would like to rest?
Yes, page 17.
Page 24.
No, sorry.
Affidavit of opposition of response number 4 and 5.
24, yes.
So to the Deputy Commissioner subject, sir, with due respect and honor, I would like to lay these few lines for consideration and intervention. That, sir, Milan School located at Padampuri Block 5, Land 5, Dimapur, Nagaland has two approach roads, one at the front side and the other at the back side of the school. Both these roads are used by the parents, teachers, and students to reach the school. The approach road at the back side of the school also leads to the residence of Mr. Atubu Chopi, who is the petitioner. The said approach road, around 100 meters long, connects a private residence, Milan School, and Atubu Chopi's residence. I want to bring to your knowledge that Mr. Atubu Chopi has constructed a gate at the said approach road, restricting movements for the school staffs, parents, and students. He has claimed the approach road as his private property. In my humble request, it is my humble request to you to kindly look into the matter and remove such legal construction and open the road for public use. Intervention in this regard will be highly appreciated. Now, in my respectful submission, Your Worship, by filing this complaint, the complainant, we are not claiming title right over the road in question. We have just requested the Deputy Commissioner as Revenue Officer to look into the matter as to whether, because the petitioner is claiming it to be his private property, so whether it falls under private or public land. We are not claiming title. This is not a complaint regarding title to decide the title, not a complaint to decide title. Your title has to be decided by competent civil courts. Pursuant to this, may I take your worship now to the writ petition, page 24, the summon. Page, page 49, I think. Sorry.
Yes, page 49.
Page 49, this is the summon. The summon was issued by the Deputy Commissioner, Your Worship, as by the Revenue cum Settlement Officer. That I would like to impress upon Your Lordship is that this order is passed from the revenue side. This is sitting as a revenue court. You're the summon, Lordship may see. It has been issued by the Revenue cum Settlement Officer. Now, may I take Your Lordship to page 50. This is the written statement filed by the parties.
Page 50.
Page 50. This is by the complainant, addressed to the before the Revenue cum Settlement Officer. I would just like that. Now, petitioner has filed a written statement which is at page 56. This is a written statement filed by the petitioner, page 56, addressed to the revenue officer. So all the proceedings were before the revenue officer. Now, what was the issue for determination before the deputy commissioner? Now, Your Lordship, I come to my affidavit in opposition. The issue for determination before the deputy commissioner.
Yes.
Page 17.
17 in your affidavit.
Yes, affidavit in opposition.
Yes.
This is the impugn order. Para 3, to save time, para 3, the third line. From half.
Yes.
To determine whether the gate, Lordship has got it, to determine whether the gate was constructed by respondent falls on a private or public road.
Falls on a private or public road.
This is not regarding title. That is what I would like to impress upon your Lordship. Now, on this, the finding. The finding is at page 20.
Yes.
Second line. Further, a meticulous perusal of the spot verification report submitted by the DLR also depicts a scenario wherein respondent is in excess of occupation of 14 letters. That is, at present his position is in such and such, though the area mentioned in his pata is such and such before verification. Furthermore, it is noted that the distance from the respondent land residence and his gate is 7 feet and does not fall under his pata number 1314, tag number 226/1811. As such, without any documentary evidence to prove otherwise, it can be said that the gate that has been constructed on the approach road does not fall under the private road. Now, in my responsible submission, Your Worship, whether the land where the petitioners constructed gate falls under private or public road, or that can be determined only on the basis of the revenue record. And the revenue record is in position of the revenue officer. So based on the record, the petitioner is relying on affidavit or sale deed, but this issue, whether it falls under the private land or public land, can be determined only based on the record, not based on the affidavit or sale deed. So in my respectful submission, Your Worship, there is no illegality. Now, if at all the petitioner is claiming that no, it falls under his private land, just because of the fact that he has constructed, he has repaired the road, doesn't give him the title over it. If at all petitioner is claiming his title, or let him file a title suit. Now, coming to the prayer of the petitioner, what is the prayer? Prayer of the petitioner is page 24. There's relevant points. There's one prayer. In bold, quashing and setting aside the order or number such and such dated 15/4/2025, passed by the respondent number 2. In other words, the petitioner is praying for a writ of certiorari for quashing and setting aside the impugn order dated 15/4/2025. Now, as I have submitted, Your Lordship, from the record of the proceedings, the summons, the written statements, whatever complaint, and also from a bare reading of the impugn order dated 15/4/2025, it is clear that the order has been passed by the Deputy Commissioner in excess of the power under the Assam Land Revenue Regulation Act. In other words, the impugn order is quasi-judicial order. Now, under the given facts and circumstances, Your Lordship, I raise a preliminary objection whether a writ of certiorari will lie against a quasi-judicial order. And since I raised a preliminary objection on maintainability, Your Lordship, and para 3A and B of my affidavit of opposition, Your Lordship, para 3A and in my respectful submission, Your Lordship, the issue of maintainability has to be decided first, as held by the Honorable Apex Board in 2003, 7 SCC 410, National Highway Authority versus Conjoint. And here, Lordship, Justice S.K. Samau is one of the another member in this case.
Okay.
May I take your Lordship to para 6?
Para 6.
In this relevant portion of
Yes.
the respondent then filed a writ petitioning the High Court for refund of the amount. On the pleadings before it, the High Court raised two questions, which A, whether the forfeiture of security deposit is without authority of law and without any binding contract between the parties, and also contrary to Section 5 of the Contract Act. And B, whether the writ petition is maintainable in a claim arising out of a breach of contract. Question B should have been first answered as it would go to the root of the matter. Because this is on maintainability, this ought to have an answer taken up first, because it will go to the root of the matter, Your Lordship. Now, taking into consideration the fact that the impugned order dated 15/4/2025 is a quasi-judicial order, Your Lordship, as per the law laid down by the Constitutional Bench in Ujambai case, Your Lordship. The present writ petition is not maintainable. AIR 1962, Supreme Court 161. Para 19. Para 50, in area it will be para 15. In my decision, in there it will be para 15.
Para 15.
Now I come to
the yes.
Yes. What is the position with regards to an order made by a quasi-judicial authority in the undoubted excess of jurisdiction in presence of a provision of law, which is admittedly intraverse, that is, which has been exercised? Now, it is necessary first to clarify the concept jurisdiction means authority to decide. Here I am saying that the judicial Dimapur has taken up as far as the impugned order in excess of the jurisdiction and power under Assam Land Revenue Regulation. Whenever a judicial or quasi-judicial tribunal is empowered or required to inquire into a question of law or facts for the purpose of giving a decision on it, its finding thereon cannot be impeached collaterally or on an application for certiorari, but are binding until reversed on appeal. Where a quasi-judicial authority has the jurisdiction to decide a matter, it does not lose its jurisdiction by coming to a wrong conclusion, whether it is wrong in law or in fact. Now, it needs to be reversed in appeal. Here, Your Lordship, the problem is for the petitioner. Now, under the Assam Land Revenue Regulation Act, Lordship may be aware there's a provision for appeal before the review board.
Yes.
Here, we don't have. But then,
here we approach the commissioner.
Or petitioner can come under 227, not under writ, 226. Not under 226, they can come under 227. or your worship can go to the civil. Now, in my respectful submission, as per the law laid down by the constitutional bench in Jamai's case, your worship, the impugned order dated 15/4/2025, your worship, this being a quasi-judicial order, your worship, no writ of certiorari lie, your worship. Now, not only that, even a division bench of this order, your worship, has held that writ is not mentionable. May I take your worship to para 14? That will be the last page. Second last, para 14,
Yes.
19. Next page. Then fifth line from the bottom. Once the deputy commissioner, or should I record it?
Yes, once the deputy commissioner
Passes
passes.
necessary order in the application pending, the persons aggrieved, if any, will have the statutory remedies under the Assam Land Revenue Regulation 1886, or in the alternative may seek a remedy before the civil court or competent jurisdiction, as the case may be. Your Lordship. Now here, your Lordship, if the petitioner go to the civil court, at least if petitioner wishes to approach this honorable court, it has to be under 227, where this honorable court can exercise the power of superintendence, your Lordship.
What was the issue in this DV judgment? Here also.
Para 6. The issues are different.
Okay.
Issues are different. Here, as a Lordship, as I've stated, your Lordship, the issue is not about title at all. Even the impugned orders is what the issue is, what is to be determined. It's not about title.
Yes.
But even otherwise, now since the revenue court has held that the land does not fall, over which he has constructed gate doesn't fall within his private land, your Lordship. By passing that impugned order, no right of the petition has been violated, even 300A afforded by the Constitution, so as to invoke the jurisdiction of this court under Article 226. Now,
admittedly, even you are admitting that it is not within your Pata land.
Yes, yes.
Saying that you acquired it by exchange.
Yes.
With that Felix.
So, in fact, your Lordship, while making my preliminary submission, in fact, I have it even goes to the merit also, your Lordship. So, from the pleadings, what the petitioners has first in the pleading, it is petitioners held that there is a violation of natural justice, though that submission has not been advanced in the pleading. But I've taken your Lordship to the summons. Summons, they have filed a written statement. Course examination also was done. So the question of violation of natural justice does not arise, your Lordship. Now, in my affidavit, whatever I have submitted, your Lordship, I have taken those grounds in my affidavit, affidavit in opposition, at para 3. Para 3 is the on maintainability, and para 5 and 8, in order to save time, your Lordship.
Para 5 and 8.
Para 5 and 8. 3 on maintainability, and para 5 and 8 on merit. And another issue which was taken, your Lordship, to which I could not raise in my affidavit of opposition is on the Village Council Act, which was referred to.
Yes.
Now, the documents which the petitioner is relying on. May I take your Lordship to page 40?
Page 40 of the petition.
Petition. Because this I have not dealt in my affidavit of opposition, page 40. This is the Pata issued by
It's
the
the
revenue
petitioner's Pata,
department
yes.
to the petitioner is relying on this, not on the Pata issued by village council. Now, page 33, before issuance of Pata, this is the mutation.
53. Yes, this is the mutation.
Now, petitioner is claiming to have derived his right over his land based on the mutation and the Pata issued by the revenue officer. Now, at the same time, now he is questioning the jurisdiction of the revenue authority. Petitioner, in my respectful submission, is contradicting himself. That submission has no legal basis.
Yes.
Just to sum up, Your Worship, so as per the law laid down by the Constitutional Bench in Ujamba, Your Worship, no writ of certiorari lies against an order passed by and against quasi-judicial. That is one. Moreover, even going by the judgment passed by the division bench or this honorable court in writ appeal 12 of 2019, Your Worship. Now, once the deputy commissioner passes an order on the revenue side, that any aggrieved party, they can either go, they can prefer an appeal or they can approach the competent civil court. Not so, this writ petition under 226 is not maintainable. In fact, entertaining this writ petition will go against the decision passed by the constitutional bench and also by the division bench of this noble high court. Now, admittedly, when the petitioner himself admitted it does not falls under the Pata, Your Worship, by that impugn order, no constitutional or legal right of the petitioner be under Article 30 of the Constitution, it has been violated. So, in fact, petitioner cannot invoke the writ jurisdiction under 226, Your Worship. And 40.
Yes.
The issue before the complaint and the issue before the revenue court was not regarding the title, right title in interest, but whether the land in
Whether it was public road
is under private public land. So it is not about title, which though the petitioner has tried his best to impress upon Your Lordship that the revenue court cannot decide title. Revenue court by the impugn order has not decided title. Only said that it does not fall within this land. If the petitioner is aggrieved, by that, and then desires to claim title over that land, he can file a title suit and approach the competent civil court. But not indirectly, he cannot come this to establish his title. And there's no illegality, lastly, in the order passed by the Deputy Commissioner Dimapur, because whether that land in question falls under the private land or public land can best be determined based on the revenue, not on the basis of sale deed agreement whatsoever. So in my and as the impugn order has been issued, after issuing summon, after the parties have filed a written statement based on record, the question of violation of natural justice does not arise. So in my respectful submission, there is no merit in this writ petition, and this petition is devoid of merit and liable to be dismissed. Obliged.
Okay. Yes, any reply?
Very brief reply, madam. Now, it's very clear that the issue was not relating to title,
Mm.
title over the property,
Mm.
over the land. But I'm an illegal occupant of public land. So therefore, if I'm an illegal occupant of a public land, how I should be proceeded against?
Mm.
When the law has, my lord, my lady, very well settled that if the statute prescribes a manner, a thing to be done in a particular manner, it can only be done in that manner and no manner and no in no any other manner. Therefore, in that case, my lady, there's an eviction act.
Mm.
Because if they proceed under this act,
Unauthorized occupation.
I also get certain rights
Mm.
to defend. Now, under this act, if they proceeded, my lady, just for it first, and my lady, this is the case that well settled law. If a thing has to be done in a particular manner, it has to be done in that manner only. There is paragraph 40, my lady. I'll not read that. Paragraph 40. I've marked that paragraph 40, which I have not submitted. So therefore, if it's not an issue of title, I'm also not saying, my lady,
Mm.
that please declare the title in my favor. I'm not asking for title. I also know that to establish that my title, I have to go to the, it will be done only in the civil court. But this impugn order will come in the way. This impugn order will come in the way, declaring this is a public road. Therefore, I had to come under 226 because there's no revenue board. I cannot approach the revenue board here. So usually in Nagaland, we come under 226. My lady, it is clearly submitted that it's a quasi-judicial body, the revenue authority. Orders passed by quasi-judicial bodies are amenable to reach jurisdiction under 226, we all know. The two in the cases that are submitted, my lady, supplied, that at serial number 3, my lady, serial number 3, in a list of authorities.
Yes.
This was also passed under Article 226. Then Potovic is in the last case, that was also under 226. Under the Eviction Act, my lady, if the deputy commissioner passes an order, I can go to the commissioner in appeal. But here, I have to come under 226 only. So if they're saying this is a public land, I mean illegal occupant of an unauthorized occupation of public land, then proceed against them. Relevant law, follow the due process of law, not in this manner. That's all, my lady.
Okay.
Therefore, this order needs to be interfered and set aside.
Yes, Your Lordship, just one short reply to that.
That option of Nagaland unauthorized occupation
No,
of public
just
land is
on that,
also
Your
there.
Lordship, I'm on that. Supposing tomorrow, I construct a gate near the BSNL, blocking the entrance to this high court, and I say, I advance the same submission, yes, I'm not claiming title. But then, since I have already constructed, if I am to be evicted, it has to be by way of eviction process. That is what I have understood. Whether
No, that is what he's saying. He's saying that the eviction order could have been passed after issuing notice.
yes. Now, I blocked the public road by constructing gate, and now I'm saying, okay, now I'm not claiming title, but at least there's a process. No.
My lady, may kindly see, village council has not raised the objection. The deputy commissioner never raised the objection. The police never objection. Only 2 persons came forward and raising objection.
Who are
Why?
affected? Who are affected? And the school children who are affected, though they are not here.
Except these 2 persons, no one is claiming it's public land.
Okay. Heard counsel for the petitioner, Mr. Ibti Longcheng. Also heard Mr. Moa Inchen, learned government advocate for the state respondents, and Mr. TB Jamir for the respondent number 4 and 5. Hearing is concluded. Order reserved. These two, no? This one and this one. You give me the photocopy printout.
For admission, item numbers 9 and 10.
This lordship.
Yes.
Item 9 and 10
Albert.
are analogous, lordship. The simple issue involved in this with petitions is whether on acquittal, the charge from the criminal case, the petitioner is entitled for the forced salary during the suspension. That is the sole question of law involved in this writ petition, lordship.
Back wages.
Yes,
Whether he is
well,
entitled
I
to back
am
wages.
claiming for full salary only, not other consequential benefits. This is the second round of litigation. Earlier, what the petitioner, item number 9 and 10, approached this court and your lordship disposed of the to-writ petition with a direction to the Director General Police to consider my representation as appeal under the rules and dispose of.
Okay, okay. I remember. So you, because the petitioners had not filed appeal.
So accordingly, my representation was not, appeal was not accepted and denied my claim. Therefore, I'm compelled to approach this honorable court again by way of this petition. Lordship, may kindly see the facts. A criminal case was registered against the petitioner. And in view of registration of the criminal case, I was placed under suspension at page number 19. I'm holding WBC number 203, lordship.
Yes, to the
Page 19 is my suspension order, lordship. Next page is the type copy. I'm reading my suspension.
Yes, yes.
So this was issued in view of registration of the criminal case. Whereas number so Shri Mahabir Baswan was arrested by South Police Station, Kohima on so in connection with South Base case number so 1998 for illegal activities practice which involves monetary giving and receiving for electoral gratification. Now, therefore, pending investigation and final report, since the detailed inquiry is to be conducted to verify the veracity of the misconduct, the undersigned in exercise of power of comfort by sub-law so 27 Nabil Rose 1967, hereby place number so under suspension with effect from 10/7/2008. It is further ordered that during suspension period, he will remain in Badan Headquarters Jammu Kohima and will not leave the station without bureau written permission of the undersigned. He will report daily to the SM during the suspension period. During the suspension period, he would be entitled to sustained allowance, the amount equal to leave salary which he would have drawn if he had not on leave half average pay and other allowances as admissible under the provisions of FR 23. So this was dated 31 July 2017. Inquiry was held.
Then after that, inquiry.
And by order dated 13/3/2020, the petitioner was reinstated service by imposing some penalties, lordship. Lordship,
Where is that?
I'm reading page 21.
21.
Mr. Lordship, got it? May I read?
Yes.
This order dated 13/3/2020. Whereas in order placing number so Mahabir Baswan of first NDB Badan Jammu Kohima under suspension by number so. And whereas a disciplinary proceeding was initiated against the delinquent by framing one article of charge, right? Avoiding inquiry officer and presiding officers to inquire into the charges from the same. The inquiry officer has submitted the report where the charge from against the delinquent found proven. The undersigned issued memo number so proposed a major penalty of dismissal from the service to be imposed on the delinquent. Whereas the delinquent in his reply to the memo has submitted a representation praying for leniency and proposed penalty on him. Now, therefore, the undersigned in stress power covered by rules the following disciplinary rules hereby impose the penalty of withholding increment for 2 years with cumulative effect and reinstate him in service with immediate effect. The period of suspension till reinstatement is treated as such, not entitled
for bail and allowances, but without breaks of service for pensioner. This is one of the immunity. I'm not challenging the entire order, but the Lordship, I'm challenging the penalty imposed.
The last two lines.
Yes,
This one, period of suspension till reinstatement is treated as such, not entitled.
yes. So suspension period is about 20 months, Lordship. So I'm claiming for false salary for that period of 20 months only, not more than that, Lordship. Now, after the petitioner was reinstated on 13/3/2020, the criminal case pending before the criminal court against the petitioner was disposed of. Next page, Lordship. Page 22.
Page 22. Yes.
This is order dated 30/4/2024. This order will cover both the petition. So
Okay.
I'm reading this order.
The petitioner here is Tilak Das.
No.
Mahabir Paswan.
Mahabir Paswant. I'm reading this order, Lordship, order date 30/4/2024.
Yes, please read.
1. The accused person Tilak Das, Sunil Durvedi, and Mahabir Paswan. Mahabir Paswan is the petitioner here. And Sunil is in the another petition. He's the petitioner in the another petition. Paswan are present before this court with Suiso. Learned Suiso, 3. Notice fixed for CC of 3 accused persons. 4. Learned ABB submits that there's a prima facie case against accused Tilak Das and Sunil Jawberti for committing forgery of the appointment order of Vijay Kumar. This allegation is against the other accused, Lordship. Hence, attracting the charge under section 460 of IBC, and that there is prima facie case against Mahabir Baswant for chaining the accused Niraj Baswant of rupees 2 lakhs by offering him a government job and the IRB under Nagaland Police, thereby affecting the offense under section 40 of the IBC. She further, it should be or she, Lordship. She further submits that the accused persons are all government servants and have received a legal gratification. As such, the offense under section 13 of the Prevention of Corruption Act 1988 is attracted against all of them. She does brief for framing of charge under section 13 of the Prevention of Corruption Act against all accused persons. Section 465 IBC against Tilak Das and Sunil Jawberti, and section 420 IBC against Mahabir Paswan. This is me, Lordship. The charges was 420, number 5. Learned counsel for the accused person submits that the credits of the offense are not made out against the accused person. 6 Hartport Bardis. The court shows that the FIR was lodged by Niraj Paswant, who was later arraigned as who accused in the present case and charged with section 171E IBC. The result of the charge sheet shows that the charge sheet is purely based on the statement, admission of the accused person during police interrogation, and there are no independent findings of the IO. The result of the statement from an Isai Suinsu under section 161 CRPC shows that the same is based on the finding of the inquiry officer made in his inquiry. The report of the inquiry officer Abil Gigon reflects that 1. Suinsu Prasad had lent money to Niraj Paswant, and that it was certain from Shri R. Suinsu, Commandant Suinsu, that accused Mahabir Paswant was on 40 days earned leave. However, besides the statement of the Suinsu Prasad and Shri R. Vikram Ising, the rest of the findings of the inquiry officer are merely reproduction of the statement of the accused persons made before the inquiry officer. Herein, this court is inclined to state that the statement, admission, confession of the accused person made before the police officer are not admissible and cannot be admitted into evidence by virtue of section 3 and Evidence Act. Number 9. The inquiry officer has alleged that a copy of the forged appointment order that the Suinsu in respect of Vijay Kumar of Bihar was obtained. However, the result of the list of the witness doesn't show any appointing authority who will substantiate the claim of the prosecution that the appointment order of Vijay Kumar is forged. Further, there is no forensic expert listed
and no report of forensic expert to prima facie show that the accused person Sunil Chowdhury and Tilakdas has forged the appointment order of which I give. That is allegation against other accused, Lordship. Thus, this court is of the opinion that there is no incriminating materials against the accused person Tilakdas and Sunil Chowdhury under Section 6. So that is the finding of the other accused person. Number 10. The proceeding has prayed for framing of charge under Section 14B against the accused Mahavir Pasu and present petitioner, Lordship. However, the result of the charge sheet and the accompanying documents do not show any
Okay, so you were discharged.
Yes.
Both the petitioners.
Both the petition. Both the petition.
Person Tilakdas discharge.
So relevant part, Lordship. Paragraph 13.
Paragraph 13. Yes.
From 13 only 3 paragraphs. Prosecution has prayed for freeing of charge under Section 13 of the Prevention Corruption Act 1988. However, Section 3 and 4 of the SEC Act has empowered a special judge, especially appointing to take up the case under the Prevention of Corruption Act 1988. Hence, this court has no jurisdiction to take up the case under SEC Act. Thus, upon considering the police report and the accompanying materials on examination of the accused persons and after hearing both the parties, this court considered the charges against the accused person to be groundless and deemed it fit to charge the accused person under Section 239 CRPC. As there is no ground for assuming the commission of offence charged against them. The accused person, namely Mahavir Paswan, is the petitioner, Lordship. Tilakdas, Sunil Chowdhury is the petitioner in the other petition. Are accordingly discharged from liabilities of charges under Section 420. So by this order, the petitioner was discharged from the criminal liabilities in the criminal case. After discharge from the criminal case, I've submitted a representation. Next page. However, this representation was not considered by the authorities. Therefore, page 29, Lordship.
First, your kind authority to issue. Okay.
Page 29 is the order passed by the Honorable Court, Lordship.
So the bill was filed, and then what did the appellate
No, this
authority?
Honorable Court directed the authorities to consider my representation to be treated as
an
appeal
appeal.
under Section 17 of the
So what was the order of the appellate authority?
Lordship, may kindly come to
Annexure
page
8.
34. I'm reading the order, Lordship.
Yes.
This is order dated 26 August 2025. Whereas the Honorable Court, Kohima bench, through its order dated 4/8/2025, has directed the Director General Police to dispose of the representation. This interesting, Lordship, marked as Annexure E, which authority has not received. Before I reading the remaining sentence, Lordship, may kindly come to page 27.
They are saying they have not received this.
But the receipt is already there by the PHQ, Lordship.
Yes, the seal is there on top.
Yes. So this is false false final statement, Lordship. Which authority has not received? Submitted by NC Mahavir Paswan. So. And whereas on going through the representation, the applicant on acquittal and discharge from the criminal charge is requesting and claiming the arrears fee and allowances with service benefits from the date of suspension as per provision of FR 54B. And whereas the appellate authority on the result of the developmental proceedings in its entirety has observed of disciplinary authority has issued order number so dated 13/3/2020. That is this one of the appeal orders. Imposing penalty of 2 years in agreement is established with cumulative effect for misconduct committed by applicant, which warranted for suspension and is justified. Now, therefore, the undersigned finds no reason to review or alter the order issued by the disciplinary authority. So I'm aggrieved by this order as well, Lordship. Therefore, the only issue to be decided in this writ petition and what the writ petition is whether petitioner
Whether they're entitled to that
Yes.
20 months pay and allowances.
before I refer to the judgment in support of my case lordship. I'm just referring one document, the affidavit of opposition filed by the respondent's lordship. Findings of the inquiry officer, all these are there, but I'm not referring to that. What was the case before the inquiry officer, before the disciplinary authority? Page 25 of the affidavit in opposition.
Page 25. Yes.
This is the case before the inquiry officer against the petitioner. A statement of witness issued by delinquent officer, witness number 339 NC Mahavir Paswat. First, it may be I'm reading Lord. I was working at DG Bangalore as a cook, he's a cook before suspension. I knew Sunil because of his frequent visit to DG Bangalore and official duty with senior officers. Sometimes in 2015, Sunil came to me saying that he is in need of financial help to review his house, which was hit by flood during monsoon. So saying his condition, I feel for him and to loan him a sum of rupees 2 lakhs, which I borrowed from a relative Niraj Paswan. Niraj Paswan is the complainant here in the case. At that time, I had money that it should be I had no money that I borrowed from Niraj, who was a relative. And I had given that money to Sunil, who needed money for his personal problem. I reviewed Niraj in October 2018. Niraj had called a panchayat in the village for the same issue in 2018. I never promised employment for Niraj while taking the money from him. I had said as personal reason while taking the loan. Niraj lied about the incident when I couldn't review the money on time. Niraj Paswan did ask me to help him get appointment at the Kalian police, to which I had clearly replied that I have no knowledge about how any appointment is made. He is only a cooperation. The money given to me by Niraj is a completely different issue altogether. It was given as loan and had nothing to do with the employment conversation that we had earlier. Sunil never mentioned anything about Telak while taking the money. I soon came to know of Telak only after coming to jail. I never talked to Telak on the phone. While in South Police Station, Kohima last year, the IO asked me whether or not I took money from Raj, to which I replied that I did as I need money for personal reasons. The IO asked me about my unit, my present place of posting and my native place. IO also asked me if I knew of a Telak class, to which I said I didn't know him before we came to the police station. The IO also mentioned some names and asked me if I knew of them and asked me for their phone numbers, but I couldn't see anything as I didn't know them to begin with. I had borrowed money from Niraj, and then he asked me to return the money. I paid 40,000 only as I had only that much at the time. And that is when the problem started, as Niraj was insisting that I pay the full amount. The IO also asked me about Sunil. I said I don't have any objection with Sunil that he has taken the money from me. IO also asked me how I had handed the money to Sunil, and I said that I had given the money in cash in BRL after taking out money from the bank, which Niraj had deposited. Biraj knew that I had given money to Sunil and Sunil that he would give back the money in 6 months without taking the money. I admit that I had taken the money from Niraj Paswan and a case was registered against me for being unable to repay the loan on time. I admit that I am guilty for this misunderstanding and I kindly request the Sunil authority to look into me. What was the case, Lordship? I borrowed rupees 2 lakhs from the petitioner and the other petition. From one Niraj.
From one Niraj.
And thereafter, that money was given to the
That's
petitioner in the other case, in view of his personal problem at home. So that was the transaction, few lakhs transaction between me and the Sunil, and Niraj was the complainant. So that was the case before the inquiry disciplinary proceeding, as well as the case before the criminal court. Now, Lordship, may kindly see, on consideration of all these aspects, the criminal court found that there is no ground to proceed with the charges against the petitioner and discharge the petitioner from the criminal liabilities. Now the question is whether an acquittal or discharge from the criminal case I'm entitled for the full salary during the suspension. The suspension was made in view of registration of the criminal case. The criminal inquiry as well as the criminal case is based on the same set of facts, Lordship. Therefore, in view of the acquittal of the petitioner from the criminal liabilities, he is entitled for the back wages. I mean, my pay is confined to full salary only, Lordship. Full salary during the suspension period.
No, that is the only point now.
Yes.
That is the only point. Whether the acquittal in the criminal case and in the departmental case, if it is on the same set of facts,
that is the issue.
whether that was on the same set of facts and whether you are entitled to get your full salary back, the 20 months salary.
Why I'm referring to the statement of the person accused is that, Lordship, the finding of the inquiry officer is contrary to the statements and the facts of the case. Because see, I've made a specific statement in my writ petition at paragraph, Lordship, may kindly see my writ petition. Paragraph 16, Lordship.
16.
Yes. My writ petition for page 12. I'm just reading the paragraphs, Lordship. That the respondent authorities by filing affidavit in opposition in division number 237 of 2024 brought on record the finding of the inquiry officer dated 7/9/2019 and the subsequent memorandum dated 9 November 2019. The petitioner was not aware about the finding of the inquiry officer as the same was never served to the petitioner. It is stated herein that the petitioner was summoned by the higher officer on several occasions in connection with the unfounded allegation leveled against him. The petitioner being mere NC, is a cop still. In the police department had to obey the advice and instruction of the higher officers. Be that as it may, the petitioner denied the allegation of accepting illegal gratification and illegal activities during the inquiry. It is stated herein that the petitioner is from the state of Uttar Pradesh and common language is Hindi. As such, the petitioner doesn't understand English language. The contents of the findings of the inquiring officer was read over to him, explained and translated by his counsel, and as per the explanation given thereof, the petitioner here states that contains in the finding that the petitioner voluntarily admitted to his guilty is not his statement given before the higher officer. He never pleaded guilty of accepting illegal gratification. It is also pertinent to mention herein that when the petitioner was summoned by the higher officer, the petitioner requested the higher officer to exonerate him if there is any commission on his part to the allegation level against him. He never pleaded guilty, Lordship. And the statement of the present petitioner, the delinquent officer, is very clear, which I've just now referred. It was just a money transaction, loan transaction between the petitioner here and the other petitioner in the other petition. And there is nothing to show that I've accepted gratification, illegal gratification. Any
The
candidate. His name is
inquiry officer's report is annexed
annexed in the affidavit.
in the affidavit.
This is quite lengthy, and most of the contents are pertaining to that Niraj, Dilak, so in order to save them, not reading that inquiry report. Therefore, Lordship, my submission is that the developmental proceeding and the criminal proceeding is based on the same set of facts. And therefore, in terms of the judgment rendered by the apex court, and in view of the acquittal of the petitioner and discharge of the petitioner from the criminal case, is entitled for the full salary during the suspension period. I'm not claiming for any consequential benefits, service benefits. I'm just claiming my full salary because during the suspension period, Lordship knows 75% has already been paid. So I'm claiming only 25% area. I'm referring to three judgment of the Lordship. First, 1999, 3 SAC 679. Paragraph 2 to 9. That is the facts, Lordship. Lordship, in order to save time, I'm just reading paragraph 2. Paragraph 2, Lordship. Very Lordship.
Paragraph 2, which yes.
Whether the criminal proceeding and the proceeding in the criminal case launched on the same basis, on the basis of the same set of facts, can be continued simultaneously is a question which groups up biennially in service matters and has once again arisen in this case, following circumstances. So I'll take your Lordship to paragraph 34, noting the facts. Paragraph 34 is at page 695. Paragraph 34.
34, yes.
695. I'm reading paragraph 34. There is yet another reason for discarding the whole of the case of the respondents. As pointed out earlier, the criminal case as also the criminal proceeding were based on identical set of facts, namely the raid conducted at the appellant residence and recovery of incriminating articles therefrom. The finding recorded by the inquiry officer, a copy of which has been placed before us, indicates that the charges from against the appellant were sought to be proved by the police officers and bench witnesses who had raided the house of the appellant and had effected recovery. They were the only witness examined by the inquiry officer, and the inquiry officer relying upon the statement came to the conclusion that the charges were established against the appellant. The same witnesses were examined in the criminal case, but the court, in consideration of the entire evidence, came to the conclusion that no search was conducted nor was any recovery made from this appellant. The whole case of the prosecution was drawn out and the appellant was acquitted. In this situation, the finding that the writ in this situation, therefore, where the appellant is acquitted by the judicial pronouncement with the finding that the writ and the recovery of the residence of the appellants were not proven, that would be unjust, unfair, and rather oppressive to allow the findings reported at an ex parte criminal proceedings use that. Paragraph 35. That since the facts and evidence in both the proceedings, namely the criminal proceedings and the criminal case, were the same, without there being an iota of difference, the distinction which is usually drawn as between the criminal proceeding and the criminal case on the basis of the approach and the burden of proof would not be applicable to the instant case. Paragraph 36. For the reasons stated above, the appeal is allowed The impugned judgment passed by the division bench of the High Court set aside, and that of the learned single judge, insofar as it purports to allow the writ petition, is upheld. The learned single judge has also given liberty to respondents to initiate fresh disciplinary proceeding. In the peculiar circumstance of the case, especially having regard to the fact that the appellant is undergoing this agony since 1985, despite having been acquitted by the criminal court in 1987, we would not direct any fresh developmental inquiry to be instituted against him on the same set of facts. The appellant shall be registered forfeit on the post of so and shall also be paid the entire areas of the salary together with all allowances from the date of suspension till this reinstatement. Within 3 months, the appellant would also be entitled to his cost, which is 25 as prescription.
Okay, let's continue.
Lordship, I was referring to the judgment
Yes.
1999 to the ACC. Lordship, that case also similar to the present case, Lordship, because in both the proceeding, that is the disciplinary departmental proceeding as well as in the criminal proceeding, the proceeding is based on the same facts. Therefore, my case is covered by that section, Lordship, where the Honorable Supreme Court held that on acquittal charged from the criminal liabilities, the officer is entitled for acres of salary. As I have submitted, Lordship, I'm not claiming for any other service benefits. I'm just claiming for the full salary area.
No, but in this case, which has been referred to, they had challenged the entire proceeding.
First.
Hmm.
But I'm on principle, let alone this case.
Here, have you
Thanks,
challenged the proceeding? You have not challenged it.
No, I'm not challenging the proceeding, Lordship. I'm challenging the two immediate orders whereby my appeal has not been considered. And my second decision, Lordship.
But these impugn orders were a result of the inquiry proceedings.
Correct.
So without challenging the inquiry proceedings and the inquiry report, can you come before this court praying only for quashing the order?
Against the finding and the decision arrived to by the authorities based on the inquiry report.
Because
Lordship,
you see
impugn
your prayer is only to quash the impugn order of the appellate authority.
Two orders, Lordship. 13/3/2020. First impugn order, Lordship. 13/3/2020, if I'm not mistaken.
13/3/2020 and then 26/8/2025.
13/3/2020 was issued based on the inquiry report, against which I filed an appeal as directed by the Supreme Court, and my appeal was rejected by the present impugn order.
Okay, that is
Therefore, there is no question of challenging the inquiry report. My humble submission, Lordship. Because inquiry report is already culminated.
Now you are coming with the plea that the inquiry departmental proceeding as well as the criminal proceeding were on the same set of facts. That is your submission. So here in this referred case, that was the case, and so the court said that on the same set of facts, it cannot survive the departmental proceeding. So the departmental proceeding was quashed, if I'm not mistaken. So accordingly, it was quashed, and then the full black wages were allowed. But in this case, you have not assailed the
petition. The legal officer was acquitted in the present case. The case referred to why?
No, that is all right. But here you have not assailed the entire departmental proceedings. That's what I'm trying to say. Anyway, yes, then. Yes.
Second judgment, Your Lordship. 2024. One is CC 175 on the seminar issue, Your Lordship. Paragraph 1 to 7, 11, 12, 28 to 30, and 34. I'm reading paragraph 2. The identical allegation in both the proceeding was that the appellant altered his date of birth from so-and-so to so-and-so and his standard mark sheet. It was alleged that this was done to project himself as having attained majority at the time of the agreement. The appellant denied the charges. Asked about the overriding and the application, the appellant stated it was possible that in the application form he might have written initially as so-and-so and thereafter corrected it as so-and-so. He, however, maintained that his date of birth is so-and-so. 5 witnesses were examined in the tribunal. These very 5 witnesses were also examined in the trial, apart from 8 other witnesses who are also examined at the criminal trial. The inquiry officer in the tribunal proceeding found the charges proved and the disciplinary authority by order to be so dismissed the appellant from the service. The appellate authority also dismissed the attempt to have the order reviewed and the penalty reconsidered also in that. At the criminal trial, the trial court convicted the appellant for an offence under section so and sentenced him to undergo 3 years imprisonment along with the fine of so. However, the additional district and sitting judge so by judgment and order so allowed the criminal appeal and declared the appellant. Paragraph 6. The appellant thereafter represented for his statement. Subsequently, he filed a writ petition after so for questioning the dismissal order so. The order of the appellate authority and the orders refusing to review and consider the above said orders. The little single judge, by his judgment, that is so, dismissed the writ petition by holding that standard of proof in the criminal proceeding and the criminal proceeding is different. The little single judge found no infirmity in the order of disciplinary authority. The writ appeal filed by the appellant has also been dismissed. By reiterating the findings of the learned single judge and by further elucidating as to how the parameters for judicial review against an order and a criminal proceeding are limited and circumscribed, being aggrieved, the appellant isn't appeal before us. First, we kindly come to page paragraph 11. I'm scanning other paragraphs, Lordship. Paragraph 11.
We are also
conscious of the fact that mere acquittal by criminal court will not comfort on the employees a right to claim any benefit, including reinstatement. Paragraph 12. However, if the charges in the criminal inquiry and the criminal courts are identical or similar, and if the evidence, witnesses, and circumstances are one and the same, then the matter acquires a different dimension. If the court in the judicial review concludes that the acquittal in the criminal proceeding was after full consideration of the prosecution evidence and that the prosecution miserably failed to prove the charge, the court in the judicial review will grant retreats in certain circumstances. This court will be entitled to exercise its discretion and grant relief if it concludes that allowing findings in the disciplinary proceeding to stand will be unjust, unfair, received. Each case will turn on its own facts. Lord, may kindly come to page paragraph 28. 28, 29, 30. Expressing my benefit of doubt and horrible acquittal. There's not that much remember, but I'm just reading the sheet. Use and judgment are not to be understood as a magic incarnation. A court of law will not be carried away by the mere use of such terminology. In the present case, the appellate judge has recorded that Exhibit B3, the original mark sheet, carries the date of birth so, and the same has also been proved by the witness examined on behalf of prosecution. The conclusion that the acquittal in the criminal proceeding was after full consideration of the prosecution evidence and that the prosecution miserably failed to prove the charge can only be arrived after a reading of the judgment in its entirety. The court in its judicial review is obliged to examine the substance of the judgment and not go by the form of the expression used. We are satisfied that the findings of the appellate judge in the criminal case clearly indicates that the charge against the appellant was not just, not proof. In fact, the charge against not proof by very prosecution evidence. As held by this court, a fact is said to be disproved when, after consideration the matter before it, the court had a belief that it does not exist or consider its non-existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it does not exist. A fact is said to be not proof when it is neither proof nor disproof. Paragraph 30. We are additionally satisfied that in the detail of the finding of the appellate judge, the disciplinary proceeding and the order passed therein cannot be allowed to stand. The charge were not just similar but identical, and the evidence witness and circumstances were all the same. This is a case where an exercise of discretion we quash the orders of the disciplinary authority and the appellate authority as allowing them to stand will be unjust, unfair, and impermissible. This case is very similar to the situation that arose in the same so. Last paragraph, Lordship, 44. Accordingly, we see beside the judgment of DV special so. We direct that the appellant shall be reinstated with all consequential benefits, including seniority, notional promotion, fitness, fitment of salary, and all other benefits. As far as the back wages are concerned, we are inclined to award the appellant of 50% of the wages. The direction become light within a period of 4 weeks from the date. So, Lordship, this judgment also support my case because in that case, discussion made by the apex court is pertain to when the two proceedings is based on the same facts and an acquittal and the discharge from the criminal case, the officer is liable for the false salary and full back wages, Lordship. Now, Lordship, we can consider what is the allegation made against the present petitioner. First, accepting illegal gratification and section 14D IBC, that is cheating. I've already referred to the statement made by the petitioner before the inquiry officer. No offense of accepting illegal gratification has been proved. And the criminal court also, no evidence was found in order to charge the petitioner under the relevant law section. Therefore, the criminal court discharged the petitioner from the criminal liabilities. In other words, Lordship, the petitioner was placed under suspension based on a frivolous allegation. The allegation was not proved. Therefore, my humble submission is, Lordship, the respondent authority should bear full salaries during my suspension period of 20 months. I'm not claiming.
In this judgment, they have given 50%. The court has
that is
given
back wages,
50%.
not salary, full salary. Other benefits was also claimed in this judgment. But here I'm blaming for the area salary only. I'm not blaming for promotion, increment, whatever, nothing.
Back wages is the salary.
Other benefits are also there, Lordship.
Back wages is salary. Because, see,
Nothing's to elevate the Lordship.
because it depends on the discretion.
Lordship.
There are other judgments also which
Yes.
says that it depends on the discretion of the
Even in 20 months,
authorities.
Lordship, we can consider one aspect. The petitioner will be getting only 30 lakhs, 1,20,30,000 only.
No,
But
what
then
I'm
a bit
trying to
Lordship
say
on
is,
that.
even if the court quashes the disciplinary proceedings and the order, but the discretion is upon the authorities to either to give or not to give the area wages.
Yes.
That is, you're also aware of that.
Therefore, Lordship, my prayer, I made 3 prayers based 14 of my writ petition.
First is that next H, that is the appellate authorities order.
Yes.
Yeah,
Second
then-
is,
Then the second is to pay the full salary during the period of suspension.
we have already paid 75%.
So 25%
Yes.
is left.
And
Then-
third is
Then
to
third is
decide-
to set aside that annexures.
pertaining to denial of pay and allowances during suspension period. More or less similar prayer, Lordship.
Annexure C is that the first order
Yes.
of the disciplinary authority. Okay,
So
yes,
there is a little bit clear, Lordship.
yes.
Open.
On the same set of facts, that law is clear.
Yes,
Disciplinary proceeding and criminal proceeding.
I'll come to you, my lord. My submission will be relying on my paragraph affidavit in the opposition, paragraph 4, 5, 6, and 7, 8, 9, and 10. In order to save time, I'm not reading the paragraph, my lord. But my submission will be confined to those paragraphs. My first submission, my lord, since my learned senior colleague has already mentioned regarding the facts, I'm not going into the facts. The impugn order, your lordship may kindly see the impugn order 13/3/2020. This order was passed basing on the findings of the disciplinary proceedings, my lord. And my lord, the petitioner has not challenged the the disciplinary proceedings. In the earlier writ petition also, he has not challenged. Here also, he has not challenged. But this order, that impugn order, was outcome of the disciplinary proceeding conducted on 7/9/2019.
There's
That is
annexure
Annexure C, page number 21, writ petition. And your lordship may kindly see the findings, disciplinary proceeding findings, page number 17. Annexure 2, page number 10.
1 minute.
Annexure 2, and the relevant paragraph is at page number 17.
Page 17 of your counter.
Affidavit in opposition, yes, ma'am.
Has it been served on the petitioners?
Yes, my lord. Yes.
This inquiry report. Page 17, yes.
So basing on these findings, impugn order dated 13/3/2021 must pass. And my lord, in this impugn order, the petitioner is challenging only he's aggrieved, partially aggrieved. He's partially aggrieved in regard to the withholding of the increment, my lord. And my lord,
No, withholding of his pay.
yes,
Pay
my
and
lord,
allowances.
only the pay. But why, my lord, this pay? Your lordship may kindly see that impugn order, page 21.
Page 21, yes.
The last second paragraph, kindly allow me to read this line, my lord. And whereas the delinquent in his reply to the memo has submitted a representation praying for leniency on the proposed penalty on him. The petitioner has submitted reply praying for leniency. That means the petitioner is not aggrieved by the disciplinary proceedings, my lord. Only thing is he wants only the leniency, my lord. That is why minor penalty was imposed to the petitioner. Your lordship, in the last paragraph, it says, now, therefore, the undersigned in exercise of the power conferred by Rule 7, Clause 4 of the Nagaland Service Discipline and Appeal Rules, 1967. Your lordship, may kindly see that rules.
Discipline and appeal rules.
Rule 7, Para 4, withholding of increments of pay. It is coming under minor penalties.
Withholding of the censure, withholding of pay. Yes. Yes.
Here, the petitioner has voluntarily admitted the guilty, my lord. He is admitted. That is why minor penalty was imposed to the petitioner. That is my first submission, my lord. And second, my lord, in regard to the criminal proceedings and the disciplinary proceedings, my lord, your lordship is very much aware that disciplinary proceedings and the criminal proceedings are entirely different. They operate in different field and have different objectives. Acquittal by a criminal court would not debar an employer from exercising the power to conduct departmental proceedings in accordance with the rules and regulations. Therefore, my lord, in the present case, judicial review, the scope of judicial review is limited, my lord. Unless there is violation or inconsistent with the principle of natural justice, my lord, opportunity has been given to the petitioner. And my lord, if the disciplinary proceedings act in violations of the existing rules or has come to the has unfair judgment, my lord. If the authority has taken unfair judgment, then the judicial review can, this honorable court can interfere, my lord. So, my lord, in this regard, my lord, I want to rely on three judgment, my lord. Kindly allow me to rely, my lord. Excuse me. Your lordship, may kindly see the 2023 10 SSC 675. Relevant paragraph is at para 25 and 26. I have highlighted the relevant paragraph, my lord.
24.
May I read, my lord? Para 25 and 26. May I read?
Yes.
In Nelson Motis versus Union of India, it was observed that the question whether departmental proceedings could have continued in the face of acquittal in criminal proceedings and had no force as the nature and scope of criminal case are very different from those of departmental disciplinary proceeding, and an order of acquittal therefore cannot conclude the departmental proceedings. Whereas 26, acquittal by a criminal court would not debar an employer from exercising the power to conduct departmental proceedings in accordance with the rules and regulations. The two proceedings, criminal and departmental, are entirely different. They operate in different fields and have different objectives. In the disciplinary proceedings, the question is whether the respondent is guilty of such conduct as would merit his removal from his service or a lesser punishment, as the case may be, whereas in the criminal proceedings, the question is whether the offense registered against him under the PC Act are established, and if established, what sentence should be imposed upon him. The standard of proof, the mode of inquiry, and the rules governing inquiry and trial in both the cases are significantly distinct and different. My lord, I kindly said 2022 15 SSC 190. Paragraph 18, 19, 21, and 22.
Yes.
Very good. Para 18. Recently in N. Kangaraj, after decision of this court on judicial review, the power of the High Court in a departmental inquiry and interference with the finding recorded in the departmental inquiry, it is observed held that the High Court is not a court of appeal over the decision of the authorities holding a departmental inquiry against a public servant. It is further observed and held that the High Court is concerned to determine whether the inquiry is held by an authority competent in that behalf, and according to the procedure prescribed in that behalf, and whether the rules of natural justice are not violated. It is further observed that if there is some evidence that the authority entrusted with the duty to hold the inquiry as accepted, and which evidence may reasonably support that conclusion that the delinquent officer is guilty of the charge, it is not the function of the High Court in a petition under Article 226 of the Constitution of India to review or reappreciate the evidence and to arrive at an independent finding on the evidence. Para 19. In para 9 to 14, this court had considered other decision on the power of High Court on judicial review on the decision taken by the disciplinary authority as under. Clause 9. In state of AB versus Sri Rama Rao, a three-judge bench of this court has held that High Court is not a court of appeal over the decision of the authorities holding a departmental inquiry against a public servant. It is concerned to determine whether the inquiry is held by an authority competent in that behalf and according to the procedure prescribed in that behalf, and whether the rules of natural justice are not violated. The court held us under. The High Court is not constituted in a proceeding under Article 226 of the Constitution, a court of appeal over the decision of the authorities holding a departmental inquiry against a public servant. It is concerned to determine whether the inquiry is held by an authority competent in that behalf, and according to the procedure prescribed in that behalf, and whether the rules of the natural justice are not violated. Where there is some evidence which the authority entrusted with the duty to hold the inquiry has accepted, and which evidence may reasonably support the conclusion that the delinquent officer is guilty of the charge. It is not the function of the High Court in a petition for a writ under Article 226 to review the evidence and to arrive at an independent finding on the evidence. Kalau kindly say para 21 and 22. Applying the law laid down by this court in the aforesaid decision to the facts of the case on hand, we are of the opinion that the High Court has committed a grave error in interfering with the order passed by the disciplinary authority, dismissing the respondent delinquent officer from service. The High Court has erred in representing the entire evidence on record, and thereafter interfering with the findings of fact recorded by the inquiry officer and accepted by the disciplinary authority. By interfering with the finding recorded by the inquiry officer, which as such were on appreciation of evidence on record, the order passed by the High Court suffers from blatant illegality. From the findings recorded by the inquiry officer recorded herein above, it cannot be said that there was no evidence at all which may reasonably support the conclusion that the delinquent officer is guilty of the charge. Now, as far as the submission on behalf of the respondent delinquent officer, that as he has been acquitted in a criminal court, and therefore he cannot be held guilty in a disciplinary proceeding is concerned, the aforesaid has no substance. From the judgment and order passed by the criminal court, it appears that he has been given the benefit of doubt. Even otherwise, the standard of proof which is required in a criminal case and that of the disciplinary proceedings is different. The fact that the criminal court acquitted the respondent by giving him the benefit of doubt will not in any way render a completed disciplinary proceedings invalid, nor affect the validity of the finding of the guilt or consequential punishment. As held by this court in a cadenary of decision, the standard of proof recorded in criminal proceedings being different from the standard of proof recorded in departmental inquiries. The same charge and the evidence may lead to different results in the two proceedings, that is, finding of guilt in departmental proceedings and an acquittal by giving benefit of doubt in the criminal proceedings. The Lordship may kindly refer 2021 14 SEC 735. Relevant para is 21.2 to 2.7.
Yes.
Merit, my lord. Instead of AB versus Sri Rama Rao, a three-judge bench of this court held that this is the is already referred in the previous case. The Lordship may kindly allow to reach 21.6. 21.6. In Union of India versus P. Ganesikaran, this court held that the High Court in exercise of its power under Article 226 and 227 of the Constitution of India shall not venture into reappreciation of the evidence. The High Court would determine whether, number one, the inquiry is held by the competent authority. Number B, the inquiry is held according to the procedures prescribed in that behalf. That is, there is violation of the principle of natural justice in conducting the proceedings. The authorities have disabled themselves for reaching a fair conclusion by some consideration which are extraneous to the evidence and merit of the case. The authorities have allowed themselves to be influenced by the irrelevant or extraneous considerations. The conclusion on the very face of it is so wholly arbitrary and capricious that no reasonable person could ever have arrived at such conclusion. The disseminate authority had erroneously failed to admit the admissible and admissible evidence. The disseminate authority had erroneously admitted inadmissible evidence which influenced the finding. The finding of facts is based on no evidence. In para 13 of the judgment, the court held that under Article 226, 227 of the Constitution of India, the High Court shall not reappreciate the facts or evidence and differ with the conclusion in the inquiry in case the same has been conducted in accordance with law. Go into adequacy of the evidence, go into the reliability of the evidence, interfere if there be some legal evidence on which findings can be based. Correct the error of fact, however grave it may appear to be. Go into the proportionality of punishment unless it shows its conscience. So, my lord, here, petitioner is not aggrieved by the disciplinary proceedings, my lord. And he is voluntarily admitted and basing on the representation submitted for the leniency before the authority, the impugned order dated 13/03/2020 was passed. And there is, so my lord, there is no illegality and the decision taken by the authority is justified, my lord. And in regard to the impugned order dated 26/08/2025, passed by the appellate authority, it was passed basing on the direction given by this honorable court. And
No, to reach a logical conclusion,
yes, my lord.
it has to go up till the appellate authority.
Yes.
So that is only
Yes, my
proper.
lord. Yes.
That is proper.
So there is no.
The appellate authority has also upheld
Yes, madam.
upheld the disciplinary authority's order. That's all.
So that is my humble submission, madam.
If you kindly permit me to 1 minute. First, you kindly see the rules, discipline and rules. 1967. Rule 16 and 17. That is the bill provisions. Rule 16 and 17.
Yes.
I'm reading Rule 16. A bill against orders imposing penalties. A government servant may appeal against the order imposing upon him any of the penalties specified in Rule 7 of the appellate to the appellate authority, specified on this behalf and decision. There shall be no appeal against the orders of the appellate authority. Rule 17, Roshin. Appeal against other orders. A government servant may appeal against an order which denies or varies to this advantage his pay, allowances, pension, or other condition of service as regulated by any rules or by agreement or. Worship, I'm not reading the remaining. Admittedly, the impugned order dated 13/3/2020, by which the petitioner was registered in service, by imposing two penalties have been issued, and against that order, petitioner have filed appeal. Under
No penalty. Why two penalties? One penalty only. Stoppage of increment.
Agreement and I'm referring to the impugned order. Yes. Page 19. Now, therefore, the understanding and excess of bowel comfort by Road Social Service Discipline Rules shall impose penalty of withholding of increment for 2 years with cumulative effect. That is one. And reinstate him in service with immediate effect. The period of suspension till reinstatement, that is another. Because he denied my.
That is not a penalty. That is not a penalty.
So
The
this
penalty is only the stoppage of increment. As far as back wages are concerned, that is entirely discretion of the authority.
yes.
So
this
only one punishment.
this impugn order was issued based on the inquiry. The inquiry officer never recommended for withholding of increment or not to be the whole allowances. Because why I'm submitting that, Lordship, my learned friend has made a submission that I have not challenged the inquiry, tribunal inquiry, finding up the tribunal inquiry, Lordship. In the tribunal inquiry and the report of the tribunal inquiry.
No,
They were
department
recommended-
inquiry is against you. The
Yes,
report is against you. And basing on that, the disciplinary
impugn order.
authority has issued the
Yes.
impugn
So it
order.
is that I filed it with Lordship, as per the rules. Therefore, the question of challenging the inquiry proceeding doesn't arise here. And I'm not aggrieved by the entire contents of the statement of the Lordship. I'm aggrieved by withholding of my salaries and non-payment of bail allowances during the suspension period, Lordship. Therefore,
Like I said, there is not much scope for this court to interfere.
that was true.
Hmm.
It is the discretion of the court.
Let's see. Anything else?
If similar cases also been cited by this honorable Lordship,
Hmm.
I'm just producing a copy of the record looking for your advice. Where this honorable directed to be full languages in view of the acquittal from the criminal case. Thanks a slight difference, however, Lordship, the question of law said unequivocal, the petitioner has been granted for languages, full children's.
But in this case, the inquiry was dropped. Inquiry instituted against the petitioner and the charges were not.
Yes, that
The
was dropped, but
departmental inquiry was dropped.
my languages was denied. That is how the petitioner approached this court.
No, that's why
Yes.
the facts are different in the sense that in here, the charges were
There was
proved.
inquiries.
Charges were proved. Whereas in this case, the charges were not proved and the departmental inquiry was dropped. So
Even
there was
after
every
dropping the
reason.
criminal inquiry, Lordship, the respondent denied languages. That is how the petitioner,
No,
that
no, no.
petition approached this court.
That's why I'm saying there is a difference. There, the authorities could not have denied because the charges were not proved. Here, the charges were proved. So that is why the distinction. Anyway.
Public.
Okay. Attorney counsel for the petitioner, Mr. Wati Jamir. I also heard Mr. Tipapong, learned government advocate for the state respondents. Matters disposed. I'll dispose of the
Procedural
paper.
petitions.
Oh, yes, yes.
Item
So
number 9.
same grounds.
Only the date of suspension is different.
Same problem.
Same ground. Yes, both. Okay, WP 203 and 204. Chamber disposal.
Much obliged.
Orders, item number 15.
But this one also. Bring out. Yes.
Maybe
Return service
if it's
report
on
1 to 7.
still waited. The matter come up after 2 weeks early.
Learned counsel for the petitioner, Mr. Foseko, what is present? Stopped. The office note dated 7/4/2026 indicates that the return service report in respect of respondent number 1 to 7 is still awaited. Stop. Accordingly, list the matter after 3 weeks. Yes.
Basically.
For orders, item number 16.
None appears for the appellant when the matter is called. Stop. On 19/3/2026, none appeared for the appellant. Stop. The matter was again listed on 2/4/2026, and on that day also, none appeared for the appellant when the matter was called. Stop. Lists the case after 1 week, and on the next date, necessary orders will be passed if the appellant remains unrepresented. Yes.
For orders, item number 22.
Yes, may I please your lordship. This item is filed for withdrawal of 25 statutory fee which was deposited during the filing of make appeal 1 of your lordship, which was disposed by order dated 01/08/2025, your lordship. The order has been given in Annexure 8, page 6 to 2020, page 23.
So it was allowed.
Yes, it was partly allowed. Area 33, your lordship.
In view of my following, this is partly allowed, and the claimant is entitled to a total compensation. Directed to pay the compensation with 6% interest on the date of filing the petition. So actually, this has to be adjusted against the award. Normally the court directs that the statutory deposit should also be adjusted against the award. In fact, the claimant should have come before this court. Have you paid the award as calculated by this court?
Your lordship, the claimant have not approached the complainant till that, your lordship.
So was it increased by this court or decreased? What was the total? What was the original award? 8 lakhs.
Yes, your lordship. It was decreased, your lordship.
Where is that? The original award, the amount of the original award, where do we find that? Okay, first para. The instant application has been filed by the Oriental Insurance Company Limited / appellant in MSC Appeal number 1 of 2023. Stop. Para heard learned counsel for the applicant Ms. Kim Penyu. Stop. It is submitted that the MSC Appeal number 1 of 2023 had been preferred by the present applicant, challenging the judgment and award dated 29/8/2022 passed by the learned MSCT Mokokchung in connection with MSC appeal number, no, not MSC appeal, it should be MSC case number 18 of 2019. Stop. It is stated that the MSCT Mokokchung had awarded an amount of rupees 8 lakhs with interest. Stop. By disposing of the MSC Appeal number 1 of 2023, this court, by judgment and order dated 1/8/2025, had partially allowed the appeal of the applicant slash Oriental Insurance Company and had awarded an amount of rupees 3,70,000. Stop. The Oriental Insurance Company slash applicant was directed to pay the compensation with 6% interest from the date of filing the petition. Stop. Paragraph. The learned counsel submits that the statutory deposit of rupees 25,000, which was deposited before the registry of this court while filing the MSC Appeal number 1 of 2023, is still lying with the registry, and it is therefore prayed that the applicant slash Oriental Insurance Company may be allowed to withdraw the statutory deposit of rupees 25,000. Stop. Para. This court has considered the submissions of the learned counsel for the applicant and perused the judgment and order dated 1/8/2025 passed in MSC Appeal 1 of 2023. Stop. It is seen that this court had partly allowed the appeal preferred by the applicant herein and has interfered with the award of rupees 8 lakhs with interest, which was granted by the MSCT Mokokchung in MSC Appeal number 18 of 2019, and has instead awarded rupees 3,70,000 to the claimant respondent. Stop. Accordingly, this registry is directed to allow the applicant slash Oriental Insurance Company to withdraw the statutory deposit of 25,000, which was deposited before this court, before the registry of this court. Do you remember when it was deposited? The registry of this court at the time of filing the MSC Appeal 1 of 2023. Stop. I stands disposed. Yes.
Much obliged.
For unlisted motion, item number 39.
Yes. This is against, what is the impugned judgment?
Your impugned judgment is at page 8 to 10. Your impugned judgment has passed without hearing the parties. And the honorable judge, after delivering the judgment, told us go to the High Court for an appeal. That was the exact word what he told us. The fact of the matter here is that, Your Honor, on 31st/3/26, we were given someone to appear for final hearing of the case, fixing 2nd April. Then on 2nd April, when we were seated in the room, the Deputy Commissioner Boka came inside. Straight away, he read out the judgment. On the other hand, he has told us to come prepare for final hearing of the case. So after reading out the prepared judgment, he just told us that if you are not satisfied with my judgment order, you can go for an appeal. Your Honor, the judgment order was passed on 2nd April 26, this month. Now, without complying with the order of Nagaland Code Section 29, which gives a period of 1 month period for an appeal, he had informed the case agency to prepare the payment and send to him about a week back. So yesterday evening in the night, we got the information stating that the Deputy Commissioner has told the Deputy Commissioner, he signed a copy telling us to file the appeal. Then, after that, but he did not disclose that 1 week earlier he had given order to the case agency to submit the money for disbursement. Now, the fact of the case here is that he had divided the money 50-50 to a person who is not a resident of the village. Now,
what is this WPC 148 of 25?
148 of 26 is the order which was given by this honorable court telling that Deputy Commissioner, instructing Deputy Commissioner to dispose of the division in terms of
dispose
this problem, disposal of this.
Have you annexed here? Have you annexed this order dated?
It is in the writ petition, Your Honor, at the
This
page
PC 148 75. Compensation for constructing IGGL
last portion, Lordship.
has been directed to be distributed between the Lishayan village and the petitioner in the ratio of 60%, 40%. The case of the petitioner is that he is the owner of land on which they will construct. Oh, this was filed by the
Opposite party.
by the opposite party.
Lordship. So the facts were pointed out and it was directed to the Deputy Commissioner for disposal.
40% of the compensation amount. Third party should not be set aside in does not touch an inch of the petitioner's land. Not the petitioner's Okay. So it was stated that directed that a deputy commissioner will decide the matter.
Lordship. Your Honor, the fact of this case goes back to 2024. Lordship, if you kindly take page 115 of the main petition. Page 115. Lordship, the present petitioner, Bilen, is a recognized village. It has its own chairman of the village, GP of the village, and it participates in the electioneering census.
Hmm.
Now, being a recognized village with the proper defined boundaries, gas company pass through the land for connecting this gas agency in this lower range.
Hmm.
Now, by this survey order of 115,
Hmm.
115 in the main petition.
No, I'm just looking for the impugn order.
So 115, it starts that a proper spot verification was made by 6 departments.
Hmm.
And in that, if we see the noting, this is done by this Land Record Survey Nagaland.
Hmm.
After the Land Record Survey Nagaland drew this map, it was countersigned by the SDO Civil Ralan
Hmm.
and verified by this District Land Survey Officer Boka.
Hmm.
In spite of verifying this map, the SDO Civil started playing a problem here because he wanted to take money from here. So he brought in somebody who is not a resident of this village. And from there, the whole problem started. Now, the clients, the appellants are waiting for an opportunity because they want to go to the higher station of here. In this case, SDO Civil, who had countersigned here, he drafted the application and he made the Washi sign. Then, without any reason, without giving the
Impugn order is page 110. Annexure Y. Annexure
110.
Y. 110.
Wait.
Hmm.
110.
Decided by the consent of the commissioner. So the deputy commissioner came to a finding that the compensation amount should be divided equally 50-50
without going into the reports of the case. Although the finding of the survey officer SDO Civil was made is being shown at page 115, the deputy commissioner, without seeing all this after we submitted, he passed an impugn order. Now, interesting case is that yesterday we received the copy that he is going to pass session order without waiting for 1 month period. Now,
So we'll issue notice, and in the meantime, the compensation amount should not be dispersed till the next date.
Lordship.
The instant application under Article 227 of the Constitution of India has been preferred by the petitioner praying for challenging the impugned judgment order number DCW/LR-2024/787 dated 2nd April 2026. Stop. Heard learned counsel for the petitioner, Mr. Pius Lotha. Stop. It is the case of the petitioner that by the judgment, the impugned judgment order dated 2nd April 2026, the Deputy Commissioner Woka has ordered that the compensation amount for the IGGL gas pipeline land compensation is to be divided equally, in the bracket 50-50, between the petitioner and the respondent Stop. It is the case of the petitioner. It is the further case of the petitioner that you were not heard, or what we say?
Not heard.
That
Therefore, we have included section 20 of
that
IPC.
the petitioner was not heard before passing the impugned judgment dated 2/4/2026. Stop. In the meantime, it is submitted that the deputy commissioner has issued this one. This is the letter.
Lordship, yesterday only they received this. And tomorrow is his farewell day. He wants to sign the check today and disperse.
No, but here nothing is said about
No,
The
he didn't say
dispersal-
anything about, now, we have already engaged with the cash company, the cash company told us, 1 week ahead, they have already told us to submit so that the money will be dispersed. That is why he is playing a trick here, and tomorrow is his farewell day.
It is further stated by the petitioner that the compensation is going to be released by the
DC.
by the DC Deputy Commissioner Woka at any time.
At any time.
At any time, and therefore it is also prayed that an interim order may be passed at this stage. Stop. Para. Issue notice returnable in 4 weeks. Stop. The learned counsel for the petitioner shall take steps for service on the respondent by speed post as well as usual process. Stop. List after 4 weeks. Stop. In the interim, it is directed that the dispersal of the compensation amount shall not be taken up, shall not be initiated till the next returnable date.
Noted.
What is this IA?
Well, Lordship, since they are going to disperse the amount that they ask for the information given from the office, order of the court may kindly be given to us in the evening, so that when dispatch. It's a very urgent emergency case.
No, this is for stay only.
No, but
Yes.
to mitigate this so that they will not that this way, because they are only
No,
assembled.
that I cannot say. In view of the order passed in FA number 2 of 2026, this IA stands disposed because stay is already given. Yes.
For hearing, item number 27.
You ready to take up? Let's post it another day. I've already heard 2 matters.
It's up to the Lord.
Yeah. Because there's only so much the human brain can also consume.
Then, in that case, my lord, if tomorrow, by upgrading the matter, because both of us, we've been waiting this case for 5-6 occasions. And the last moment, the moment we reach, we could not take up, that was the occasion that 5 to 6 occasions is taken place.
Otherwise, I saw that there were some directions already given by this court on earlier occasion. The government advocate was also directed to apprise the court as to why the subsistence allowance of the petitioner has not been given, because there's according to FRSR, I think after 3 months it has to be reviewed, and then it has the 75% of the pay should be given.
Yes, however, the grounds taken in this case by the state respondent is that there was a delay and the petitioner has slipped over the matter for nearly 10 years. Yes,
No, my lord.
so the question of review will not arise in this case.
My lord, here in this case,
Yes.
just to highlight the facts, if the matter can be taken up, then it's okay, but if it is supposed to be taken up,
Monday.
Monday.
Monday. List on 20, no? That will be 20, I think. Yes, 20.
Kindly upgrade the matter, not in the last item, my lord, kindly, because honestly, both of us, we've been waiting till the last moment for last 4-5 not 6-7 occasion, I think.
Okay, list on 24 in the hearing list, at the top of the hearing list.
This is much obliged.